Morning. How are you?
I'm good.
We had,
Nicer out.
we had a discussion today in the drug court team of what you would say when I asked you that question. And guess what the response was? I'm good. There is something to be said for consistency,
Well,
right? And that was the next thing that was said about you. We love that about you. The fact that you are consistent and you are consistently getting better. The fact that you say you're good all of the time, I like. It's a nice thing to say, right? I mean, that's kind of the generally accepted way of doing it. But I think that you are good. You are doing good. You and I have had a little bit of a bumpy road a couple times, but it's all been upward. In my view, and I hope it's in your view as well. It's been positive. And so today is one of those positive things. I have a couple of certificates for you. First is 200 support group meetings. That's a big deal. That's a lot of commitment. That's a lot of time and effort, and it shows on how well you're doing with that commitment that you've done there. So I'm going to sign this. I'll give both of these to you in just a second. The next one is your request for moving from phase 4 to phase 5. So I want you to tell the group summarize what you put in your letter. Tell the group why you think that you should pass from phase 4 to phase 5. Putting you on the spot.
I don't. I like that.
This is part of the growth process.
Throughout the program, these different phases, you learn different things, take those and move on to the next phase. Add to what you've learned with that. Over time, you start to develop different ways of doing things, finding out what works and what doesn't. Learn some more stuff.
Yeah, and I get it that I put you on the spot and that's hard for you to do. One of the reasons I do that is because I think that you grow every time I've done that. Every time I've asked you to get out of your comfort zone and do something that's hard for you, you've done it. And you've done it humbly, and you've done it to the best of your ability. The letters that I see you writing here, you wrote me front and back of 2 pages. When we started out, you could barely get the front of 1 page. Okay, so you are growing as a person. You are doing better, and I love that. So every time I ask you to do something hard, you're trying, and you're making good strides on that. And that's exactly what we're asking you to do here in this program, is grow from the mistakes that you've made in the past, grow toward being a bigger and better person. So I am pleased to be able to sign this. Will say to you that you are no longer in phase 4, but you are in phase 5. Congratulations.
Mr. Sequin?
Morning. How are you today?
Well, thanks.
Tell me about the last week or two. How have you been doing with your sobriety?
Doing well. Thankful for my faith. Thankful for my jobs. Staying positive. Been through quite a bit the last 10 years of life. How I've grown in that. Through the ups and downs and mistakes, and but yeah, doing well overall and staying positive.
Okay. Tell me a little bit about your statistics.
57 in phase 2, 58 self-help, 188 overall, 187 sobriety days. Oh, the CHS.
Yeah, that last number was the one I want to focus on today. I have a certificate for you in honor of 180 days of sobriety, 6 months. That's a good milestone. I'm looking forward to giving you one for 365 and then maybe 720. We'll see how far, how fast, how good that goes. But 180 days is a good number. 6 months. It's what I consider to be the basis, the kind of the initial, you're doing good. 90 days, you can get there on your own, gritting your teeth, but 6 months, that takes some change of your heart and of your mind. And so what I want to do today is say, congratulations, well done, keep up the good work. Let me sign this for you and then shake your hand. Nicely done.
Mr. Locker.
Morning.
Morning, Your Honor.
How are you?
Really good. How about you, sir?
Really good. I like that. That's excellent. Tell me some stats for you.
I have 182 days in the program, 181 sobriety days in the program, 57 days in phase 2, 276 days of personal sobriety. I just got my 9-month coin Saturday, and 58 self-help meetings.
So 9 months ago, where were you? What was happening?
Pretty bad.
Yeah,
Yeah.
that was not good for you 9 months ago.
No, I'm pretty sure I had my mom and everyone calling to make sure I'm getting in the vehicle with Bear River.
Come a long way, right?
Yes, sir.
If you had to say the difference between, if you had to put a number on the difference between then and now, what would you say? Between 1 and 100, what's the difference between those two things?
Oh, it's night and day. It's completely different.
Do you like who you are now?
Yes, sir. Yeah,
Family trying to kind of come together a little bit better? See that?
yeah, just this past weekend, my son and his wife came and cooked dinner for us, and my
Awesome.
son in Mount Pleasant came up for the weekend, and my daughter, my mom and dad. So it was a great weekend.
Yeah,
Found out that my son's coming up for the entirety of his spring break.
great.
He's made the baseball team. So
Life is good.
yeah,
I like to hear that kind of stuff. So we want to reward that kind of behavior. We're a little behind because we're just catching up to your family life, but I want to say it's an honor to honor you for 180 days of sobriety. So we have a certificate of that. Again, same thing I told David. This is kind of like what I consider to be the basics of, if you make 6 months, you've got a really good shot at making it the rest of the way. Before then, you can. You know, in the past, you've been able to stop drinking for short periods of time. But 6 months is a significant amount of time. You've done that. You're well on your way to doing sobriety for the rest of your life. Congratulations.
thank you, sir.
Changing gears, Judge.
Yep.
Mr. Wodeski.
Morning.
How you doing?
I'm good. How are you?
Very good, thank you.
Very good. All right. So tell me what, when we were here 2 weeks ago, I gave you a little bit of homework and I said I wanted you to do some soul searching.
Yes.
I wanted you to kind of tell me what changes you needed to make in your life and how you needed to do that. Not just set an alarm, but what internally did you need to do? So what did you come up with?
I had 2 sessions with Rosario. We talked, and first session we talked about like an emotional, mental level, not just physical, because I believe physical is what you're saying is just setting an alarm, and I look more mentally, emotionally of what's the cause, and for me, I think it's just the riddling fear and anxiety that I carry with me each and every week, week in and week out, of like everything else is going very, very great, you know, in my life. Work's great. What I do at the house is great. What I do in the recovery community is great. The people I associate myself with is great. What's happening with my family is great. What's happening with my wife is great. the pro-social aspect of meeting with my therapist and group and my fellow like participants, as well as my sobriety peers in the recovery community. I'm able to communicate and talk about anything and everything that's going on in life. People around the house, support needed, or maybe support even needed. But being able to articulate that to them and not just, you know, before I was just felt like I was looking in a black hole, you know, I didn't see any light. Yeah, so
This is Zachary Dickinson. This is case number 25 CR 42976. Present before the court is Mr. Dickinson, right?
Yes, sir.
Represented by Mr. Kirby. We have Mr. Hardman from the prosecutor's office, Officer Henry and Kelly from probation. We're here today for sentencing. Has everybody had the opportunity to review the PSI?
Yes, sir.
Yes, Your Honor.
Is there any reason not to go forward with sentence today?
No, Judge.
We have 201 days of jail time credit, no restitution, right?
Yes, Your Honor.
All right, so we got a couple of preliminary matters before we get started with the sentencing. First, we have explanation of duties to register as a sex offender. Mr. Dickinson is going to register as a Tier 2 sex offender. That means that he is going to register for a period of 25 years with in-person verification every 180 days. Mr. Dickinson, Officer Henry read to you the explanation of duties to register as a sex offender or child offender, duties commencing on or after January 1st, 2008. Did he read that over to you?
Yes, sir.
Do you have any questions about it?
No, sir.
Do you want me to read it to you?
No, thank you.
All right, you are going to be required to register for a period of 25 years with in-person verification every 180 days. Not really sure where you're going to be at the time you're released, but you do need to begin to register immediately after your release. Second, we have the notice of duties to enroll as a violent offender. So we didn't discuss this issue much at the plea hearing, but it's my understanding, Mr. Kirby, that you are going to waive the filing of a motion to rebut the presumption that he is to register or participate in the violent offender, right?
That's correct, Judge.
All right. And so, Mr. Dickinson, you've also been read the notice of duties to enroll as a violent offender. That's this sheet here. Officer Henry. If you understand that, or do you need me to read that to you or explain it further? All right. Next order of business is the Reagan Tokes. You're going to be receiving both a minimum and a maximum sentence today. So this is going to be what we call an indefinite sentence. So let's just say, for example, that I were to impose upon you the minimum sentence, which is a 3-year sentence. I'm not saying that I'm going to do that. I don't know. We haven't gotten that far yet. Then 1/2 of that sentence would be your indefinite sentence. So you would get a sentence of 3 to, it would be 3 to 5.5. If I were to sentence you to the maximum penalty, it would be 11 to 16.5. It is presumed that you are released at that first number, either being the 3 or the 11. It's presumed that you're released, but the Department of Rehabilitation and Corrections can, under certain circumstances, keep you up to the maximum penalty. That means if you don't behave yourself while you're in prison, they can keep you there longer. This is what we call a Reagan Tokes sentence, and we have the notification for Reagan Tokes, which I'm going to go ahead and attach as Exhibit 1 to the sentencing entry. You received that and had the opportunity to review that with Mr. Kirby.
Yes, sir.
Do you feel like you are satisfied that you have been notified about the indefinite term or the Reagan Tokes sentence?
Yes, sir.
Do you want me to read that to you?
No, thank you.
All right. Also, we have the issue of post-release control. You're subject to a mandatory period of post-release control, in this case of 5 years. That means the adult parole authority is going to supervise you for that period of time. We also have the notification that I'm going to attach to the sentencing entry as Exhibit 2. which explains to you your the notification regarding post-release control. Do you want me to explain post-release control to you, or are you satisfied that you understand it?
I'm satisfied.
And you reviewed that notification with your attorney, right? All right. Any other preliminary issues that we have?
No, I don't believe so, Your Honor.
There you are.
All right. I think I said this already. 201 days of jail time credit, no restitution. All right. Mr. Hardman, anything on behalf of the victim?
Yes, Your Honor. Miss Garrity is present, and I think she wishes to address the court.
Okay. Hello, Ms. Garrity.
Hi, how are you, Your Honor?
I'm okay. So just for the record, you're Julie Garrity, right?
I'm sorry, sir.
Julie Garrity, right?
Julia,
Julia, okay. And can you spell your first name and your last name for me?
Julia Geraghy.
All right. What do you want to tell me about this?
Okay, I know, okay?
That is really tiny writing. I'm impressed.
My glasses. Okay, though the experience was frightening in the moment at that time, it does not remain in my thoughts daily. I do not feel scared for myself when thinking of him, rather scared for others that may have the same experience or worse if he were to do something like this again. For that reason, I encourage incarceration.
Thank you, ma'am.
Thank you, sir.
Mr. Hardman?
Thank you, Your Honor. As the court is aware, this day back in August, the facts show that this defendant planned, stalked, looking for a victim that day to engage in the behaviors that he now has been admitted to, and the court will be finding him guilty of. What he found was 79-year-old Julia Garrity, who was simply going about her life, living a very independent life at that time, living on her own, in her own residence. She enjoyed living that life. That life has been changed. And a large reason for that was because of the behaviors that this defendant engaged in on that day back in August, as he stalked her from a Walmart parking lot, following her back to her residence, entering into her garage under a stealthy cloak of darkness with a mask and gloves, pinned her up against her car, and then began sexually touching her. She made the right decision at that point in time, which was to scream for help, which caused this defendant to back off, run to his car, and take off. Fortunately, due to technology, due to good detective work, the defendant was quickly found and apprehended. What was interesting about is where he was apprehended. We learned very quickly the defendant was employed at Mason Christian Village, obviously a residence filled with individuals of the same demographic as Miss Garrity, which obviously questions what his motive, what his reasoning was, and knowing that this activity that day was planned, very concerning, particularly on his part. The activities this man engaged in are above and beyond anything that we normally deal with. This is a case that is out of the ordinary. It certainly shows a great deal of planning and to engage and changing and radically affecting the life of a 79-year-old woman. As a result, we ask that this court impose a sentence of at a minimum of 8 years. It's an appropriate sentence for the two F1s. The defendant now has admitted to committing the kidnapping and aggravated burglary. I think it's appropriate under our sentencing factors, the seriousness of this defendant's conduct, and to certainly send the message not to mean the seriousness of the behavior that this defendant engaged in back in August. We would submit, Your Honor, that the GSI and the kidnapping merge, so counts 2 and 3 merge. We are obviously asking to proceed forward on the kidnapping and the aggravated burglaries counts 1 and 2 pursuant to that. Thank you.
Officer Henry, what's your take on this?
Your Honor, from what we discussed in chambers, I do believe that there would be nothing further for me to explain to the court other than proceeding forward at this time with the prison sentence and being considered not amenable to community control at this time. It would be our recommendation from probation.
Mr. Kirby?
Thank you, Judge. You are not going to hear an excuse from me or my client as to what transpired last year. Given the facts of this case, given the facts of Zach's history, the fact that he's a 30-year-old who's married, he's employed, he's a father, I think we are left with the inescapable conclusion that there is something mentally wrong. At least at the time of this offense, there was. And in which case he is in dire help of need. In talking with Zach, his wife, his mom, I don't think he's an evil person. He knew what he did was wrong. He knows what he did was wrong. He was adamant to me since I began representing him that he did not want to put the victim through a trial. He's exhibited remorse in what he did. He's unable to explain why he did it. I think what is also telling is when he was apprehended by the sheriff's office just a day or two after this offense, is he gave the sheriff's office a very candid confession for what he did. He was remorseful when he told them what happened. And to me, I think that is a cry for help of somebody who understands that they need the help. I filed a sentencing memorandum with the court that details some of Zach's history as a letter from his mother. I also spoke with Zach's wife, who is imminently contemplating a divorce action against him, but she still says that he's a good father. And she says that treatment would be appropriate for him in light of this offense. So based on the foregoing, Judge, and based upon what's set forth in my sentencing memorandum, we would ask for a sentence that does promote his effective rehabilitation and credits him the 201 days that he's already served. That's all, Judge.
Mr. Dickinson, you get the last word in all this. What do you want to tell me?
Your Honor, I'm not a terrible violent criminal. I made a terrible choice that day and harmed a completely innocent woman. I want her to know that I am sorry for what I did, and I'm thankful that she's not living in fear like she said. That's really all I wanted for her. That's all.
Mr. Kirby, the defense doesn't dispute that counts 2 and 3 merge and that the state is elected to go forward on 1 and 2. You don't dispute the merger issue. So here's the thing, Mr. Dickinson. You know, I've been a judge for 20 years now, and very seldom does a case come in front of me that makes no sense to me. Most cases make a little bit of sense, where we have somebody who has a history as a sex offender and doesn't have a particular amount of empathy for their victims. They pick out a victim that is somewhat susceptible, maybe somebody that's not going to put up a fight, or somebody that's not, that creates a situation where you're going to get away with this. It doesn't fit that box. Your only criminal history is that you have a marijuana conviction from out of state and a couple of dismissed charges. And you know, the prosecutor's recitation of this, which is unexpected to me, is what I expected, which is I have a victim that is very impacted by this and very scarred by this. I hear from Ms. Garrity, and the fact that she is tough and fears for the safety of others, also very unusual in a case like this. So it's very difficult to put this case into any particular box. But as I'm up here, Mr. Dickinson, I do three things. I punish people, I protect the public, and I try to rehabilitate offenders. Those are the three things that I do. And the number one thing that I do, Mr. Dickinson, is I protect my community. And that has to be done. I've always been of the position that you cannot go into somebody's house, even a garage that's part of the house. You just can't. Our house, our castle, as it's called sometimes in the law, that is the place that we go to get away from everything else that occurs in the world. And the fact that this took place in the victim's home, very significant to me. And I do think that, we all sort of shake our heads and be like, oh, there must be some mental health component to it, although your history doesn't really suggest that. Your history doesn't suggest that this is a particularly harsh punishment case. I do think that supervision is essential to this case. Bottom line, Mr. Dickinson, you are among those people who need to be separated from the rest of us so that we can be protected and that we can feel protected. Both of those things have to happen at once. I am going to sentence you to 8 years in prison. That is going to be 8 to 12 years in prison. Again, we have the Reagan-Tokes sentence, which is an indefinite sentence. Here is my hope, though, Mr. Dickinson, and I like to be upfront with my sentencing because I think it's fair to you. I think it's fair to the victims in the case. You become eligible for what we call judicial release after 5 years. And it is my hope, Mr. Dickinson, that you behave yourself while you are in the institution so that this becomes a 5-year sentence instead of an 8-year sentence, because I want to be able to supervise you and to engage you in some sort of treatment. So at the end of your sentence, they just don't open the door to the prison and shove you out. But if you don't behave yourself while you are in the institution, you do things that suggest to me while you are in there that you are more of a threat than I believe you to be, then the 8-year sentence probably seems more appropriate. If you commit new crimes while you're in the prison, then the Department of Rehabilitation Corrections, they make the decision whether to keep you up to the 12 years. This also includes a mandatory period of post-release control. The adult parole authority is going to supervise you for 5 years. If you violate the terms of that supervision, you can be returned to prison for up to 1/2 of my original sentence. Or if you violate by committing a new felony, then you can be returned to prison for up to 1 year or the amount of time you have left on post-release control. It's automatically whichever of those is the longer period, and it's automatically consecutive to the sentence that you would receive for that new felony. I'm going to give you credit for the 201 days that you have already done. I find that you are indigent for the purposes of fines and costs, so there will be no financial sanction. This is going to be an 8-year sentence on each of these charges to be served concurrently, which means at the same time as one another. You are going to register as a Tier 2 sex offender, and you're going to be enrolled in the violent offender database. Is there anything else we need to do or anything that I forgot?
No, not in the state, Your Honor.
I don't believe so, Judge.
Finally, Mr. Dickinson, you have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer to obtain a transcript or pay the costs, they will all be provided to you at no charge. I am going to remand you to the custody of the county sheriff for transport to the institution. Everybody who was on this side of the courtroom, just have a seat for just a second because Mr. Dickinson is on his way out, and everybody can clear out. Deputy, you can go ahead and take Mr. Dickinson out. Thank you. All right, we're in recess.
All right.
Hey,
I don't know
you
what's
did.
happening here.
Okay. Well, let's see if we can get through this today, because this is set for final summary.
Retry.
Retry. All right. Okay, I think the last place that we were at, Ms. Norman, you were there though?
I am here, Your Honor.
Okay. The last place we were at is there were documents going back and forth.
Yeah.
And the question is,
I stuck to her.
right. Ms. Norman, did you receive that?
I did.
Okay. All right. So now everybody has what everybody else has, right?
Yeah.
I think. You were able to open the one that Ms. Norman sent. We got that done. And then what you sent in was it. All right. So Ms. Norman, as to what was sent to you, do you have anything to say regarding that?
Well, reading through it, it was a little confusing to me, because he asked that the plaintiff's claims be denied, and he's the plaintiff. So I don't know.
Okay, if the parties are switched or the name on the party, then it makes sense to you. Or at least you may not agree with it, but it makes sense in terms of what's being said.
Yes.
Okay. All right. I guess, and Mr. Stanford, I'm gonna just ask this. Your court, in looking at it, believes that there was a what? Let me rephrase that. Strike that. Why do you believe that the resolution of the last case didn't resolve these issues? Why do you believe that the resolution of the last case did not resolve these issues?
Because she still occupied the property. I had no idea what damages or condition the property was in until after she moved out. In that consent agreement, there was the second page on that had a line in there regarding there might be additional damages due to physical damages to the property.
When did she move out?
Oh, she moved out the day before the end of that agreement that we had come to. She was going to move out by before the 31st of October, 2024. And she did that.
She did, right. She complied with that part. And then,
so
just look, go ahead.
So November 1st, I went in and did an inventory, and the pictures you saw that I've submitted to the court is what I saw when I walked in through the house on November 1st.
All right. So how much was her security deposit?
The security deposit that I was holding was I believe it was around 1,020 or 1,050, I believe.
Okay. And so the entirety of the amount, is that all damages that you're claiming in this case?
what I have submitted, on one of these forms that I turned in, I had, crossed out some numbers and, and updated the, that. Oh, my.
Well, let me ask it this way. None of it is for rent.
No,
Okay. And for all of these claims, there are receipts.
yes.
And remind me, how long was she in the unit?
You say again?
How long was she in the unit?
How long she was in the unit? She was in the unit for, from 3/23/24 and till October 31st. So about 6 months, new day.
So, for example, when was the last time the unit was painted before she moved in?
Probably about a year before she moved in.
And then she's there 6 months.
Yeah.
So why is she paying the cost of repainting?
Because her grandson wrote all over the wall, crayons. She's not paying for repainting the whole place. She's paying for to go through and touch up all these spots. And you see it in the pictures, all the crayon marks and everything all over the wall.
Yeah, but that was crayon.
Well, crayon or marker, whatever they were using.
Well, there'd be a difference in terms of cleaning, wouldn't there?
That's not dirt. That's not normal wear and tear. That's
not what I asked you. There would be a difference if it's marker as opposed to crayon.
well, I'm not sure what it was, but I tried cleaning it. It would not clean off. What I had to do is I had to repaint. You know, a lot of those markers say, even after you repaint, they'll bleed back through.
So I'm. Who did this? So I'm trying to figure out. There were items that had to move out. Who moved those items out?
I had to myself and my crew.
So how do I get to 1,090?
Oh, you're looking at it, okay. That was, well, let me review it. Well, that was the labor involved to, I had a total of 10 and a half hours moving that stuff out, loading it up, hauling it away, and dump fee on that.
So what was the hourly rate you charged?
What we have had agreed to in the lease was $100 per man hour.
Yeah, but what were your actual hours?
The hours, well,
I mean,
probably about 10 hours.
all of the labor in here, was that done by you?
Not me, or some of it was done by me personally, but most of it was my people that work for me.
And they're going to testify as to all of this?
Pardon me?
They're going to testify as to all of this?
I did not plan on having them testify, but I could, or one of them could. The other one has moved to California.
I
can provide.
Where were these doors? See, I'm going to tell you right now what I've got a problem with. One of the problems is the time it's taking to do these things.
The time it takes to what?
To do these things.
Okay.
I mean, I got you're charging $100 an hour, which is a little odd to me because if you were to hire somebody, that normally would not be the cost.
Well, it wouldn't. Well, it would be if I.
No, it wouldn't.
If I hire a handyman service to come in and do these repairs, the local handyman companies are charging in the area of 100, 125 per man hour.
But they do it quicker.
I would not say that they do it quicker.
You're going to tell me it took you almost 18 hours to replace doors?
That's a lot of work, replacing a door.
You know, that's a funny thing. Everybody thinks as a judge, I don't do anything. I just go home, crawl under a rock, and I never repair or do anything. If it takes you 18 hours to install 2 doors, you better have reinstalled the frame, had to knock it out, put wood in. There is no way it's going to take 18 hours.
I know that for a fact because there was a door that I had replaced in that building a couple of years prior to that. And I had real specific time that I've recorded on that. By the time you go order the door, go back and pick it up, deliver it to the job site.
You're paying for the order and pick up at the door?
That door's not going to appear there automatically. How am I going to hang a door if I don't have the door? I've got to go buy it. I've got to order it. Might not.
That's not a labor charge.
It's the cost of doing business. If I came to your house and put a door in, I got to include the cost of me going to the lumberyard, buying that door, delivering it to you.
Well, if it takes you 18 hours to put in a door, you're not coming to my house to do it.
Well,
I'll tell you what, because I'll have that door in by the time you get there.
Well,
there's just no way.
To install a door in an existing opening where you've got to cut and double the doors, cut the lock set or the passage set into it, bevel or mortise for the hinges. It's certainly, that's what it takes. That's the amount of time it takes to do that.
Okay. at $100 an hour, but you're not a professional in doing.
I am a professional. I'm a licensed builder. I've been doing this for over 45 years.
And it takes you 18 hours to put in 2 doors.
That's the amount of time to be involved.
Okay. All right. No, you'll just get left to your proofs. Because that is an incredible amount of time to do that. How were these 20 bulky items taken away?
They were hauled away by truck by a fellow that works for me.
It took 10 hours to get all this stuff out?
That's the amount of time we had in that portion of it.
I don't know what that means.
Well, what are you specifically asking about? The items that she left behind?
Yes.
All right. We had to pull all that out of the house. I had it in the garage for a while. We're going to having to load it in the truck, haul it to the dump or the recycle, location.
Well, how long did it take you to get it out of the house?
Well, that was the amount of time I had involved.
How much time did it take you to get it out of the house?
I'd have to double check my specific records on that, but I would suspect it's going to be 2 to 3 man hours to haul this stuff out of the basement, out of each of the bedrooms, and getting it out of the house into the to the garage.
And then charged again to load it from the garage onto a truck.
Right.
Doesn't it seem to you it would have taken less time if we're charging by time? That if you take it out, put it right on the truck, you save time.
If I have a truck ready to go to the dump, that would make the most sense. But
yes, it would.
But I was gathering stuff up to make sure we had all the debris we needed. I had to figure out how much. It was more than one truck.
Maybe you're not understanding what I'm saying. What I'm saying is you're trying to charge for time that seems to me to be extra time based upon the way that you did it.
I put it in the garage.
I heard you.
That was right where you can back a truck up to and then load it compactly into the garage. Once you see what.
How come when I say something, you try to explain to me like a rationale behind it? I hear what you're saying. I'm just saying you're charging for, you created more work.
No, I disagree.
Okay, but that's the great thing about this. I'm the one making the decision. But you created more work.
By doing what?
By taking it out, storing it someplace, then coming back and then reloading it. It takes more time than if you had taken it out, put it right on the truck and taken it away.
It's a minimal amount of difference. The garage is right next to where the house and driveway right there, where you can back the truck up to. To pack that truck, compactly, you want to see what you've got, what you got to put into that truck. You can't just randomly start throwing stuff in the truck. You'll never have all your stuff in there in an efficient load. I've been doing this kind of work for 50 years and
not very well if you're doing it this way.
Well,
I'm done with you. Don't say a word to me.
All right.
Norman, anything you want to say? Well, hold on a second before we get there. How is the plumbing her fault?
What's the question?
How's the plumbing parts her fault?
Uh, they had a, bathtub that was backed up. And they were doing something to it and they broke the trap on that and causing a leak. They were trying to, get a bathtub to drain, and broke that. And I had to go back in and, fix a bunch of drywall that got damaged and fix the plumbing, that, they had, from the leak that they caused.
Was there an inventory move-in sheet?
Yes, there was.
What portion of the lease has the $100 in it?
Pardon me?
What portion of the lease has that $100 labor charge? Which I'm not sure is legal, but go ahead.
I think Lisa, it's, there in the portion in that lease that said, if there's damages, they can repair them, or if not, they agree to hire Stanford Enterprises to take care of the repairs.
So in the lease, the tenant agrees to hire your company.
Say again?
In the lease, they can't get somebody of their own choosing to do the repairs.
No, they can't. If there's,
Well, what's this about hiring Stanford Enterprises?
well, if they don't fix it, I've got to have my crew go in and do the repairs. If they do damages and then walk away.
Where's the $100 thing? It says tenant will pay the company's standard rate. Current rate is service and trip charge of $50 plus $100, right? Per man hour.
Right.
All right. Ms. Norman, you got anything to say on this?
I do. So just kind of going back to how, when the case started and that last case, that we had the consent order for, he talked about, I believe he's talking about number 6, the defendant may be liable for damages. I was concerned about that and voiced my concerns to you, and you specifically asked him on record if he was waiving rent and monetary damages, and he said he was. His counsel was there with him.
Did somebody provide a transcript of that?
I did submit the flash drive of the video.
Right, but what date was that hearing?
10/22 of 2024.
We're running what? We're running jabs, weren't we? Pull up our copy. All right, go ahead, Ms. Norman. Well, I'm trying to find the official copy. We didn't pull a transcript, but maybe, and I saw what was there, but these days I have to be careful regarding that. But go ahead. What else were you saying?
So I did want to point that out, that he did waive those things. Also, what got us into court was because the property was damaged in the first place. And I did ask the court if I could reopen my case since Mr. Stanford was bringing this back into your court. And at the time you denied it, and there's photos of the damages that were on the property. I'm sorry, I didn't hear you.
Up on move-in.
Correct. And I called the township myself for the inspection, and the house was inhabitable. So there was a lot of things he had to fix, and then he didn't have that certificate of occupancy as well.
The certificate of compliance he didn't have.
Oh, compliance. Okay. No, he did not. My deposit was $3,500. Let's see. And he's talking about this big plumbing issue. I called him the moment that started leaking. I don't even believe we were in court at that time. And he came there and I asked him to remediate that water, or if he had a shop vac, and he said, "Don't you have a mop?" So that was a whole thing. But I was not trying to fix that. I'm not a plumber. I called him immediately. I'd like to just address quickly the amount of monies he's trying to charge me for.
Hold on a second,
Okay.
Stormy. I now see that. What? How much was the monthly rent? I just got to update myself on that.
The monthly rent was 3,300.
So in all of your, I'll come back to you in a moment, Ms. Norman.
Okay.
In all of your estimates, there's a $3,500 security deposit, not the $1,050.
That's right. Police called for 3,500, I believe. She had not paid the full deposit.
So then why did she move in?
Well, she wanted to move in. I gave her a break.
And why wasn't the lease changed to reflect that?
Well, she had agreed that she was going to get caught up and pay the difference on that.
By when?
Well, we had.
Is there anything in writing to that effect?
We have agreements that.
Was there anything in writing to that effect?
Don't know that there was some printed things that communication that we had back.
Okay. If you want to play semantics with me, we can play it all day. If you want to play semantics with me, we can play it all day, because I bet you I can beat you. Do you have a signed writing indicating anything about that security deposit that's different from what the lease says?
I have records showing what she paid. I don't have a written agreement of what transpires.
So the answer to my question is no, I do not have that.
No.
Were you able to find it?
So Mr. McCurgy was present at that hearing, and he says, "We're not claiming money damages for rent. This is only a claim for return of rent." I still have much to listen to, but that's what I've got so far.
That was on which case? That was on the first case, correct? I get why he says that, though. All right. No, I may need a transcript of that proceeding then. Prepared.
Okay.
Okay. All right. Ms. Norman, I interrupted you. You go ahead. What else did you want to point out?
The deposit, and he's making claims that the furniture, removal of the furniture, he calls the city to have that removed for free. Because when I moved in, there was furniture sitting in the driveway, and he informed me that these bulky items, all you do is call and they remove them for free. So I'm under the impression that that's what happened in this case as well. I did try to call, I did call and talk to Cindy at the township office, but they don't keep records. So
right.
But I didn't see any receipts in all of the items that he sent me either.
Didn't, but
I see these punch something or other, but I couldn't read them. I don't know what that's about.
this property was located, is it in the city or in the township? In Pittsfield?
Pittsfield, yes.
You didn't have a certificate of occupancy?
The township failed to follow their procedure as far as renewing that.
So the answer to my question is no, you did not.
Correct.
Which means you could not rent.
When she first gave me,
which means, correct me if I'm wrong, that you could not rent that property.
Technically, by law,
that's what I deal with. You know, you can call it technicality all you want. That's what I do.
And Your Honor, I don't believe that the failure of the township to do the what they are statutory.
You may have a claim against the township, but if you don't have the certificate of compliance, you can't rent it.
Yeah, I wasn't aware of that when we signed the lease.
Okay. So how much rent did she pay you? Because if you can't rent it, you can't charge her rent.
I submitted some information on how much she paid for it, and I just did that information here. Let's see. Well, she paid $4,000 on 3/21, and it's the C of O was valid at that point in time, or C, I guess technically. And again, I don't have that right here in front of me up to date. You need those numbers.
Well, wouldn't it seem to you if you can't charge rent and you can't rent it at that point in time, that you might owe her money? Or that at least gets offset as against any claim that you have?
Is that question or?
Well, if I make it a statement, we're done here.
Could you say it again? Because I didn't hear real clearly what you had said.
Monthly rent was about 3,000 something?
3,300.
Okay. If she paid rent to you at a point at which you can't rent the property nor take rent, then wouldn't you owe that back to her?
I don't think the burden should be on me for the failure of the township.
Again, you might have a claim against the township, but you don't have a claim against her.
Well, I think I do.
Okay. All right, then you keep thinking that. Here's what we're gonna do. Ms. Norman, you're not intending on being out this way anytime soon, are you?
I can be. I was going to be there today. I just was in the hospital at influenza A.
Okay. Give me a trial date. I want to clear it. I don't know. This is going to take all that long.
April 20.
April 20th.
28.
28th. Okay.
Judge Simpson?
Yes, ma'am.
Just so you know, I paid him. It's in the case that I filed before, around $15,000. And all the receipt, all of my money orders are there. Everything is there. But just so you know.
In the previous matter, right?
Yes.
Yeah, I know that based upon my memory of the previous case, you paid the money. That's not my issue. My issue is monies that you paid that maybe you shouldn't have paid. And what I'm suggesting to Mr. Stanford is that may offset any claim he has.
Okay.
So what I'm going to do is 428. I'm going to set a non-jury trial. I'll need the parties here in person. I was going to set it for April 28th, 2026 at 9 a.m. Is that right?
Yes.
Will that work for the parties?
Yeah.
For me.
All right. And then we'll decide. Pardon?
What was that date again?
April 28th.
April 28th at
9 a.m. And what I might suggest, Mr. Stanford, is that you look at how much she paid during the time at which your property did not have a COC or temporary COC, and determine whether or not you want to head forward with this case, because it may offset anything that you might be entitled.
Understand.
All right. Anything else from either side?
No.
No, thank you.
All right. Thank you. Are they ready on this?
My understanding is yes.
Hasim Yasmin versus Shannon Somerville. Yeah, I'm gonna do. Huh? I'm gonna go around and take all these doors off. Then I figure it's 18 hours for every two. That's like $900 a door. We got 1 billion of them. I could make some cash. Anyway, I'm sorry. Go ahead. Council, state your appearance.
Your Honor, I'm Hashim Yassin. I'm appearing pro se, and I would like to inform you that I believe we have come to an agreement. And
okay, why don't you stop right there and let me get this side? Go ahead.
Hi, Your Honor. Good morning. I'm Lazar Georgiev. I'm here with my partner, Justin Yu, and we're requesting permission to appear on behalf of our clients, Shannon Somerville and Joseph Walters Jackson, pursuant to MCR 8.120 under the supervision of David Santacroce.
Good morning. Good morning, Mr. Santacroce. Should I give him permission? Okay, permission to practice is granted. All right. All right. My understanding is there may be an agreement.
Yes, Your Honor. We'd like to put it on the record, the initial dismissal. Our clients have agreed to payments of $54 a month for 4 months to be made through Cash App. It will be paid on the 1st of every month, beginning next month, April 1st. And if it's okay with Dr. Yassin, we'd like to be able to prepay earlier if they're able to, but we'll stick to the schedule.
You said $54 a month? Are they in the property? What's that? What's this amount represent then?
This is for plaintiff's claims for unpaid rent. We have a copy of.
So we're here for $216 of rent?
Well, Your Honor, plaintiff has claimed.
That's a yes or no?
Yes, Your Honor.
Really?
Well, we also had, they claimed more in damages, and we had significant counterclaims in which the.
So the 216 is a resolution of those items?
Yes, Your Honor.
Okay. Because if it was 216, that would have been like a quarter of a door. I'm sorry. My bad. All right. Sir, is that a full understanding of the agreement?
yes, Your Honor, in the spirit of reaching an agreement and having peace of mind to all parties involved, we came to that agreement, and we believe that we are both benefiting from it.
Okay. Has that been reduced to writing?
We will prepare it.
You didn't do it?
Just struck.
Your students, shouldn't they have done it by now? You know, if you're going to the University of Maryland, you'd have this all done. How soon am I going to get an agreement?
Your Honor, we'll work on it, get it to the other side and file it within the next 2 weeks, if that's okay with you.
2 weeks? What do you have to do in 2 weeks? What you got? What? You just came back from break, right?
Yes.
You just came back from break. You don't have classes every day, do you?
I do personally.
You do? You're doing it wrong. You're doing it wrong. What?
I asked for 2 weeks. I said ask for 2 weeks because it's got to go over there. We've got to get a signature. It's going to go back. We don't want to be late for the court.
How does it feel with that sword in your chest falling on that for your students? No. That's fine. We'll give them two. Do you have a problem with 2 weeks?
No, Your Honor.
You really think they should do it faster though, right?
Your Honor,
No, I don't want you to do it. All right. What I will do And you're going to be doing this by way of a conditional dismissal, is that correct? All right, I will mark this file conditionally dismissed. Order to follow in 14 days. All right.
Thank you so much, Your Honor.
Thank you. Thank you. What'd you say?
I was cracking up.
I always think that. See, told you, I'm awesome. I know, Mr. Okay. Mr. Allen doesn't think so, but
Have a great day, guys.
you guys do the same.
Thank you.
Have a nice day, Your Honor. Thank you very much.
Thank you. I know. What is that? So that's done.
It's there's a lot of motions. We didn't include it in that, yeah.
Court does call the case, fixing housing 401k plan versus Erica and Aaron Ward. Council, state your appearances.
Wayne Velez on behalf of the plaintiff.
Erica, Aaron Ward, defense.
All right. I think, counsel, did I not have from you a motion to withdraw?
Your Honor.
Pardon?
Yeah.
Okay. I also have, and I don't know whether or not you were served with them because I'm not clear what entirely what Ms. Tope is doing. But did you receive from Ms. Tope a motion to remove and expunge the court's order?
Got an email copy of it that I'm aware of, yes.
Okay, so you,
I don't know the result of it though.
well, first of all, I can tell you part of the result of it is that she marked it an emergency. I did not deem it an emergency. So I set it for hearing today along with the other motions. Okay, that was the resolution. The reason did you folks receive a copy of that?
Not sure what you're referring to. I don't know anything about it.
Donna Tope's motion to remove and expunge the court's order for contempt. Okay.
I don't know. I didn't think I was.
Not received. You got an email copy. All right. So then we received, and I guess I'll deal with that one first, if you don't mind. We received then a communication from Ms. Tope that she was unavailable for her own motion today. So that motion, Donna Tope's motion will be adjourned. And I'm not changing anything. The bench warrant is still outstanding. So my next day.
March or April 14th.
14th?
Yeah.
I'm a little busy that day. March 17th, 2026, 9 a.m. So that I'll adjourn the Donna Tope's motions. Counsel, I'll leave it to you, given your motion to withdraw, as to whether or not you want me to finish ruling on the other motions or hear your motion to withdraw.
It's my understanding, the last hearing, you ruled or granted liability or the motion to stop the motion, and we're here today for a hearing on damages, which I suspect we're prepared to move forward with that might result in the conclusion of this matter, which might make my motion to withdraw moot to a certain extent, and also make the defendants, we're calling it the second omnibus motion, might make.
Pardon?
include as well.
Oh, yes. All right. Folks, what do you have to say to me on the issue of damages?
So the issue on damages, okay, so the thing he was referring to as a second omnibus motion. I just was preparing that because I was under the understanding today was the final day. You already ruled on the eviction. You were going to rule on when and the damages. Okay, so since then, there were new things that happened, such as foreclosure being posted. I've lost a lot of orders and I'm out of business. So regarding damages.
You're out of business?
Yes, and I do not have enough orders to pay my lease starting April. Most of the boarders are leaving at the end of March. They saw the posting on the door. Horse owners are like horses. They're flight animals, they're herd animals, and they're all leaving and I'm going out of business. And so I fear because of the posting of his foreclosure on the facility that he is foreclosing and possibly going into bankruptcy. And so what I'm asking for damages is that it be to come out of the court's account. And that, so that my understanding is damages is up to you. And I have no recourse to get any of my money. I'm out of business. I'm not going to have the money for April's lease because of the eviction.
Let me just stop you there a moment, okay? Because you know about the foreclosure?
Yes.
Council and it's a bank foreclosure?
It wasn't a bank foreclosure, but it was the lender.
Well, okay, the lender. Have they leaned anything in regard to that?
I'm not aware of a lien. There was a foreclosure sale on the 4th, which the lender purchased the property out of foreclosure. So the redemption period is obviously still ongoing, but.
Oh, dear. Okay. And so when we had received, and I don't know if you were aware of it, Council, I think it may have come in maybe in response to your motion to withdraw communication from your client that it was going into foreclosure. But it actually has gone through that process and then there.
Yeah, and so I just want to make sure that we're clear. So there's the foreclosure sale on the property at issue on the 4th. My client's personal house is also subject to another upcoming foreclosure sale.
That's a different one.
Those are different.
Got it. Okay, and so you have to remind me, how long was that redemption? That's not a 6-month redemption, is it? Going to be.
I believe it's 3, but
3. Yeah, that's what I was thinking. Go ahead. You were.
I filed this motion so that you would have all the information in front of you so that you could make a final decision on damages. Or whatever it's called. He asked me to be, he evicted me. He asked me to leave. I'm prepared to leave. I've found a place for my horses. Most of my boarders have already given me notice. And because of the foreclosure and the eviction, the fences that have always been falling down are falling down worse. I can't keep the horses safe, but I don't have the wherewithal or the resources to fix them. And I can't go on. And I'm prepared to, if you would be willing to prorate into the court's account 10 days in April, I would be prepared to leave in 30 days from now. And
What did you mean by that prorate into?
Well, like, so I usually pay at the beginning of the month for the whole month. I won't have the money to do that because majority of boarders
Gotcha.
are leaving.
I got you. Okay.
Yeah.
That's what you're saying. All right. This has got to be a disaster in the making, I think. When let me do this. While not holding him to it, counsel, is your client seeking to redeem the property or?
I believe in the best case scenario, yes.
Gotcha. Okay. You guys are gonna have to, so let's say he doesn't, and then there's a new owner of the premises, you're probably gonna have to leave in any event. So when can you guys leave the property?
I would love to leave April 10th, but I can leave at the end of March, if you're not able to give me a prorated lease payment for the 10 days of April.
What do you have a total in escrow?
20,620.
Say again.
20,625.
I'm sorry, Your Honor, you said that's what's in the court's escrow?
Yeah, I was asking. It was 2625.
20,625.
And you folks have already paid the March payment.
Quick question, the March payment, are we saying that was paid into the court's escrow?
Yes, they said they paid that.
Last one being February 5th.
So you don't have a March?
I do one dated March.
I didn't bring the receipt with me, but I did pay it March. I paid it. Did I pay it at the end of February because it was before we left on vacation? I think I paid it the last Friday of March because we left on vacation Sunday. So I want to make sure it was in before we left.
Did you pay?
I'm sorry, the last Friday of February. We paid it cash the last Friday of February.
Did you pay it here?
Or in Tulane?
Well,
it really wouldn't matter. Do you know what court you went to pay it?
no.
I do see it because you paid it here. It's not on the ROA. So
And then it's got to be transferred over. So 5,500 additional.
So $26,125.
How long was your lease?
It was supposed to be 7 years.
Do you have how many horses are you moving?
I'm sorry, how many am I moving?
How many? Yeah.
Just my personal horses. Everybody else,
Okay, that doesn't answer my question. You're getting like that other guy.
I own.
3. So come the 10th, as you're anticipating, you're moving 3 horses, or are you moving 3 horses and then some others that you're in care of? I guess I'm trying to.
There's 3 other horses that are absentee owners, and I haven't reached out to them yet because I was waiting to see when my leave date was. I'm gonna reach out to them and see if they want me to take them, because I'm just going to a friend of the family's and they're just pasture horses. But no, I'm not continuing this business. Does that make sense?
No, well, yeah, there's a lot more information I needed, but I'm just trying to figure out if I were to give you till the 10th, you're moving at least 3 horses, but up to 6
Yes.
total horses.
Me personally, yes.
Right. Okay. And as you're moving them, I know approximately what it's going to cost to move horses, but I don't know how far you're going. What's your cost in moving those horses? Just give me your 3.
$100. I mean, if that. It's my trailer, my truck.
Okay.
My gas.
So you don't got.
Correct.
All right. Okay, before I make a final determination of the damages on this, any other additional argument you want to make regarding the?
Yeah, a couple points.
Yes, sir.
Just so that when I'm on the same page and we're all on the same page. So I have back in June of 2025 was the last rent payment. And it was a partial payment that was the water heater. Subsequent to that, until this court directed Ms. Tope and defendants to submit money to the court's escrow, I believe there was the subject of a number of hearings prior to this that Ms. Tope had an escrow account personally where she was maintaining monies of some sort for June until, because I have, for example, as of March, a total outstanding rent due of $48,691.04. $26,125 of that is accounted for in the court's escrow account. And the other $22,000 and some change might be in Ms. Tope's escrow account, which started this whole issue. And so
can I just stop you there? You understand what counsel's indicating about the difference in the money?
One correction, I did pay Fixing Houses LLC directly in July. I paid them the full amount in July.
Okay, but we still have a discrepancy amount. So I'm going to ask you folks a question, okay? Did you give that money of these missing, I'll call them missing, but the payments that did not get to the plaintiff, did you give those monies to Ms. Tope?
They were dispersed. That's the money that was dispersed for repairs.
Okay, but what I said, yeah, okay.
Yes.
Hold it. You did not, okay, listen closely to my question because it's really important. You did not disperse those funds for repairs, right? You gave that money to Ms. Tope, who was holding it in whatever to then disperse for repairs or pay for it.
Yes.
Okay, because hold on, understand, there's a reason why I'm asking this, and there's a big difference. Okay, because what counsel's indicating, I believe is correct, but I just want to make sure on the record that we have it. The $5,500 that you would pay each month that you would have normally paid to the landlord in this case, there were some months you paid those funds to Miss Toe to hold and or to use for repairs and other things.
I believe that was August, September, October. July, I paid.
Hang on a second. Hang on. Just slow down. I didn't ask what months. I want to make sure that factually what we're, because Ms. Tope's not here, factually that's correct. Because that's what I understand also, but I don't know that you've ever been asked that directly.
Yes.
Okay. So there's then this escrow, and you're saying that that was 3 months, if I'm hearing you correctly, that you would have given the monies to Miss Toe.
I would have to look at the accounting records, but I believe it was August, September, October. I believe it was
August, September.
November 8th, right?
Our first payment was, I think that's right.
And just so that we're on the same page, I believe the November payment was paid to my client and it was a partial payment.
It was a partial payment in November. Right. So,
But I also paid
but you paid the difference of the 55 to the court. No, you paid the 55, but part of it was the check he received.
It was a double payment that month because of an error by Ms. Tope. So he received the check from Ms. Tope. He also made the payment. So that month had extra.
I believe in November, we paid the full 5,500 to the court. Is that correct? So was it 41?
You pull me
25 is what we.
You received
41.25.
Yes. He got 3,600
on top of that.
So it was more than the 5,500.
It was $3,508.96.
I remember that being paid, that because that was a check Ms. Tope sent to him, right?
I don't know how we got it, but my records show that we got it.
Right, that you got it. And the question was whether or not you could pay or whether or not you could use it. And because there was then the full amount, I said, you guys keep that money. The difference I thought was being paid into the court.
And so I accounted for that in my previous stated number. So I'm just trying to bridge the gap between what the court has and what hopefully should be in Ms. Tope's personal escrow account.
Okay. And that number you gave me was 48,691.40.
Not 44, so 4 cents.
4 cents.
4 cents.
In November, though, it was overpayment. Because we paid 25 and 3,500.
Well, I don't know. We can really look at it as an over.
Okay.
I mean, because ultimately there's going to be a certain amount that should have been paid. The real question is where it went. I guess is that.
I think that's what you were going to ask for.
Yeah, that's what it was. Okay, and I know why that happened. What I did is I think I prorated. So I allowed him to keep the check. It really wasn't a double payment. So here's what I recall doing is the money that was sent to the plaintiff, I allowed him to keep that upon the court's original. And then when ordering escrow, I ordered it pursuant to the court rules so that it was ordered prorated for the period in time. And I went back, although you paid it on the 18th, it was back around the beginning. When was our first? You didn't run the whole thing, but whatever our first date in November was, I prorated it from a date in November, which is how we came up with that number. So there wasn't a full amount that was going to need to be paid in November. All right, you complied with the escrow order. If you didn't understand all that technicality and what I just said, but I understand why that number is different. And I didn't order the whole 55 for November. All right. But in terms, okay, so here's going to be the problem. And I don't know whose problem it's going to be. And this is going to, I don't think that the monies you paid were properly put into a trust account with Ms. Tepe. That causes huge problems, which I don't know what I'm going to do with entirely. Because and I'm not sure of the procedure, but typically, and I know it's changed certainly since I've had to do it, where an escrow account or an IOLTA account is mismanaged, there are ways to the state bar of making the person whole. Now, having said that, and there used to be, well, I'm sure there's got to be a way of doing that, but I just don't know how that is. Because you guys are never going to see, well, let's fit this way. You guys are never going to see that nice term. Have you asked her for the money back?
No, they're not.
I don't think that money's there. I think that that's the money that was used for replacing the sheds and all of that. So, okay, no, I'm never going to get my money back.
Here's the problem. Okay. And just follow this here. Okay. And I think, guys, he's got an Alabama shirt on. Tackle him. No, I'm kidding. Okay. Under the terms of the lease, which is the basis upon which I indicated the monies, you have to pay them, right? That money should have been paid over the plaintiff. Okay?
Money should have been paid every month.
Been paid over to the plaintiff.
Should have been paid over to the plaintiff. Okay? I ruled that.
Yes.
Okay. The problem is that it's hard. So I can't really necessarily give an offset. What really should happen in this case, right? Everything being equal and everything being what it is, and if Ms. Tepe were participating as one would think a member of the bar should, what should happen is the moment that I ruled that that money should have gone to plaintiff, regardless of whether she spent it on, if she did that improperly out of an IOLTA account, she should then pay that money to plaintiff. Right? You guys wouldn't have to pay more. Okay. That's not gonna happen. I don't think. So while let me put it this way. She may have told you those were legitimate expenses. They weren't legitimate expenses.
I hear you.
And so what I'm toiling with, just to be honest with you, is in looking at these numbers, do I hold you accountable for that? Or what do I do with it? Now, I'm toiling with that because also, which is also part of the hearing that I adjourned to the 17th, and why I would be reluctant to let counsel out right at this moment in any event, although it may be moot, is because the bond that I set on the contempt, that would be money that Ms. Tope may pay in, was specifically going to be directed toward attorney fees that were being exponentially imploded because of Ms. Tope's actions. So I'm going to ask you guys to just give me a few minutes. I'm going to step off because my problem is everybody in this courtroom has been hurt by this person. And I'm trying to find an equitable way to deal with that. Counselor.
I have one suggestion.
Yeah, sure.
And theoretically, how it should work is if the defendants have paid money to their attorneys and I owe the account, equitably, that's still their money, which as you alluded to, would mean that that money is no longer there. They would have a claim against it. So most likely through the bar agreements or whatever form they choose. My client does not have that remedy. And so, because we don't have a relationship with Ms. Tope. She's not my client's counsel. She didn't hold, I don't have an IELTS account with her, or neither does my client, for example. So in this scenario, the money that was in there, the defendants, I mean, their contractual obligation is still on them. So if they pay, then their remedy would be, they would actually have a remedy to get it from Ms. Tope, where my client really theoretically would not. I mean, there might be a creative way to do that, but I'm not aware of those. I've never had a situation like this before, but
you wouldn't me either. But no, I hear you. And that really had gone through my mind. But and that may be where I land in the next 15 minutes, right? But this is the second case in which Ms. Tope has been involved where people have been damaged. This is really the only one, however, that has damaged both sides, and then to a certain extent, the attorney on the other side, because your fees haven't been paid. And I want to just take a moment to think all that through. If I come up with something creative, I may come up with something creative, or I may not. I mean, I may indeed, and I appreciate what you're saying, Counsel. That's where I may land. But I want to just think about that for a moment, because I, quite frankly, have never been through anything like this before either. And, you know, your client's out, your fees, plus he hasn't gotten the rental income. These folks have paid, they're out at least what that difference is because they paid it over. So, and now, because of all of that, and I'm not saying it's the entire cause, but because of all of that, He's in foreclosure. You're not in business. It's a beautiful scenario. And it shouldn't be how things should work. And over my 26 years, I'm not sure I've seen one person cause this much damage. Court's going to stand in brief recess.
All right.
Yeah. Well, it's not really.
Is that ready here?
I'm just gonna get email to you.
Yeah, I'll send you down the check. I didn't.
Good morning. Are you Tyree Hartley? And this is 25 DCCR 0842. Mr. Hartley is charged with aggravated robbery. And what is the announcement?
Your Honor, this case, I think it's best that we move it to the trial docket. There's still some discovery that I've requested from the state that I don't have yet. I know they're working on that. We have discussed a resolution. We're not close, and I don't think the additional discovery is going to impact Mr. Hartley's decision to pursue a trial at this point based on what he's told
What,
me.
what are we
Judge,
waiting on?
per the standard process of this court, I would respectfully ask for a final announcement setting to allow for the compilation of that discovery. There was some stuff that Mr. Wilkerson specifically requested that Ms. Mayfield was able to get with VPD and find. We'll get that to him. There's also things this case extended out of this county. So I have reached out to detectives on task force outside of the county to get stuff from other agencies, which takes a little bit longer than just going across the street to VPD to get it and be able to get him all of that. I agree with him that we're not anywhere close. He wants a non-aggravated low pen time offer, and I'm upwards of 20 plus years, especially with his jail reports that keep piling up daily. So I would ask just for a short standard reset to allow me to get all that to him and then do a formal rejection of anything.
So, Judge, I'm sorry, I didn't mean that. So this was a case that I was appointed on after a formal rejection was done.
Correct.
So
So the rejection was just in December, and you had some time to go through it, obviously found some things you need. I'm not inclined to put it on the trial docket without the discovery complete. And so I will do one last reset. This will be the final reset for an announcement. Once Ms. Malfino gets you all the information that you've requested, you can go over that with Mr. Hartley. If nothing changes, then at that time, we will put it on the next available trial docket. As everybody knows, we don't have any kind of backlog on trials. We can get it tried very quickly. So we'll do this last one. You can get everything and then we'll go from there.
Yes, Your Honor.
Mr. Hartley, go back with the bailiff.
Thank you, Your Honor.
Thank you.
Excuse.
Yes, sir.
Thank
you. Okay, Mr. Burbank on Desarian Adams.
Now, yes.
I don't believe we're going on 3, 4, 5, 6, and 8. Would you reason?
Can't hear you. Are you whispering?
I didn't think.
The secret.
Usually I'm too loud. He's trying to be dramatic. Yeah. Not me.
Give me just a second to get these pulled up correctly. Yeah, I'll do the first one if you'll print the second one. If you'll print 0493, please, ma'am. Let's see. There's no agreement, so.
We're going for the court.
Okay. All right, sir. So is the state not, and he's gonna plead true to those, but,
We're pleading true to 3, 4,
right,
5.
but so what's the status of the,
The other ones, Judge, I have not, no fault in the state, I have not received the videos and some other evidence from it.
okay,
Reference to the actual offenses.
right?
I'm not saying when we come back, he doesn't plead true, or they're gonna have to bring their officers.
So we're gonna go through all of
Right.
the counts. He's gonna plead true or not true to
Right.
whichever ones.
But I mean, once I get all the discovery, then I may change one or two. I just want to push it along because we agree with most of the allegations.
Well, and okay, so here's the thing. If he pleads not true to allegations of new offenses, then I'm gonna set it for hearing. But I'm gonna make time in our schedule for a hearing where officers would come when it sounds like they may not have to come.
And prior to that, I will
No.
let you all know.
Yeah, no, how long, do you have that information? Does the
I
state,
think we're getting videos copied for him from these new offenses.
okay, we'll reset it 2 weeks. That way we can know everything ahead of, yeah, we're not gonna
Yes.
piecemeal
When you
it.
do it 1 week, 2 weeks, I'm not going to be. Second, 23rd.
Are they copied already?
I don't know, Judge. They probably are, to be honest.
Is that something that can get bumped up just since he's in custody and so we can get it moving forward? Here's, okay. I'm gonna reset it. Probably 3 weeks or so. If you get the videos this week and y'all have some agreement, call the court, we'll bump it up to next week. Otherwise, that gives you time to go out, go over everything with him, and then we'll get pleas of true or not true once you've seen everything.
I mean, the only thing I would submit to the court is there has to be an updated PSI anyway. I will request an update.
Yeah. Yeah, he's not gonna plead not true to something that we're gonna maybe change our mind in a week because you look at the videos. So I'm gonna reset it, look at everything. Then we'll get it taken care of. All right, you can go back with the.
I'll be back and talk to you.
Okay. No, because it's gonna have all of the wrong information on it.
You take them out of the one and you're gonna wait. No.
Give me, I'll get to it. Give me, yeah, 1 second, please. Okay, let's see, sentencing on Kevin Ross. That's Mr. Burbank. Am I right? Am I crazy? Yeah, I've been crazy.
You get mine and attachments to.
I did, yes, sir.
Judge, we need a little clarification from the court. We're kind of both semi-confused on, I think the court originally rejected 5. And so we went back to a cap of 8. Is that what you reflect also? Or then open on the MTRPs?
I mean, I don't have anything other than the new PSI in front of me. So was there already a PSI done? When I rejected something or?
No, it was just an original plea for time without a PSI.
I was supposed to say, if it's a capital, why would we have an updated PSI if it was in grade 8?
Oh, no, I think that's a mistake. I have a question about that. I said, why a PSI if it was agreed, is it a cap? And so we can look back. Can you pull up Kevin Ross's please papers or send them to me so I can see.
You want us to sit back?
No, but do it real quick. Cause number 25 DCCR 1310. We can just double check what you guys signed. Thank you. No, it's a cap of 8. That was just a, okay. And yeah, actually go ahead and I just want to make sure it was a cap of 8 on all 3. I don't know why it wouldn't be. Okay. All right. So it was a cap of 8 on 3. So, sir, you are Kevin Ross.
Yes, ma'am.
And Mr. Ross was previously in court, entered a plea of guilty in a new offense in clause number 25 DCCR 1310 to evading arrest or detention with the use of a vehicle. And then in clause numbers 24 DCCR 1198 and 1199, there were motions to revoke probation, and he entered pleas of true. And let me go figure out which. Pull that up real quick. Looks like he pled true to counts 1, 2, 6, and 7, which is the new evading arrest or detention. Well, there's, okay, so evading arrest or detention with the use of a vehicle, and then also the evading arrest, the misdemeanor, from June 13th. He pled true to both of those. Pled not true to a possession of a marijuana case, not true to possessing marijuana, not true to never becoming intoxicated, regarding a drug patch positive for cocaine, and then pled true to 6, which was that he was out past curfew at 1:39 a.m. on June 13th, and also that he's behind in his court assessed fees. And those were all the same in those motion to revoke cases. 1, he's on probation for evading arrest or detention with the use of a vehicle. And these were 4-year deferred probations from December 18th of 2024. And the second one was deadly weapon in a penal institution. So all 3 of these are 3rd-degree felonies. We got 2 motion to revokes, 1 new case, cap of 8 years on all of them. I have received the pre-sentence report update. Has everyone had an opportunity to review that report?
Princess,
Yes, Judge. Any additions or corrections to the report?
comments, you know.
Okay. And then I also have received several, a packet from Mr. Burbank with several letters from family members, it looks like, and friends, and in support of Mr. Ross. Ms. Malfino, have you had an opportunity to review those? Yes, Judge. And then it looks like there's the last jail incident report that I have is from February 17th. If you'll check, please, Ms. Warner, that there haven't been any since February 17th. And okay, Mr. Burbank, while she's checking that, you may proceed with argument.
Your Honor, at this time, I'd like to call the probation officer real short, couple questions.
Sure. Good morning, Ms. Carthen. No, Ms. Malcolm. I'm sorry. Would you please raise your right hand? That's who did the PSI. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. Go ahead.
Police court, for the record, could you state your name, please?
Sunny Malbrough. Speak
And
up, please, ma'am. Sunny Malbrough. Thank you.
And you're the probation officer for Mr. Ross? How long have you been his probation officer?
Not long at all. I think I've got, I'd only been seeing him 2 months since the admin unit.
Okay, and so 2 months from today, back?
Yes.
Okay. And have you gone out to see him or talked to him?
Yes.
And when you went out to talk to him, what were your impressions of him? I know he was in jail. Was he respectful?
Yes, he was respectful.
Okay, and you know that the court now has to decide whether or not to send him to TDC or to continue him on probation, right? You understand too that he was on probation for evading with a motor vehicle, and approximately 6 months, 5 months later, he's arrested for the same offense. Did you have a chance to take a look at the probation report? Right. Yeah. And what I want to get to real quickly is that the person who did this report, that wasn't you, right? Or was it?
The report?
Yes.
The hearing?
No, the report. Yes, I was.
No, sir.
Okay. It says here that he exhibits strengths, but he also has some concerns. Is that how you view it also?
Yes, sir.
Okay, can you explain a little bit about what his strengths are that you've seen? Very briefly.
So dealing with probation, he's pretty mild mannered than me. He acts respectful, but in the real world, I feel like he has some issues.
Okay, and what issues would that be?
Anger. And I feel like he's confused. Like most of the time when we're in probation, he calls his mom, and I don't feel like he can really understand the gravity of probation.
Do you take that because of his age, or do you think that he's just fine?
I don't think it's age, or it could be a mix of both, but.
Okay, how about do you have any learning disabilities that you remember that could also affect his judgment?
I think he's on disabilities.
Okay, and what would he be on disability for, from your understanding?
I think it was a lack of disabilities.
Knowing all that, could that be one of the causes for the way he's acting?
Yes, it could play a part.
Was he ever given the opportunity to go into any of the probation programs that could be possible to address these issues?
They're doing things happening too quick.
And in order to allow him to see if you can't straighten him out. But he was reporting.
Yes.
And doing all the other things, but the new offense happened too quick before
it really worked probation.
Anything at all. Are there programs out there or in-house or out?
We are back on the record in the case of fixing housing fixing housing 401k plan versus the wards. Council is present and the wards are present. Folks, here's what I'm going to do, and let me just explain the beginning of one of the things I wanted to check on during my break. There may not be a remedy through the bar. The only reason I say that is because at a previous hearing, Ms. Tepe had indicated she was not acting as an attorney and therefore there was no need to put it into an IOTA. Sure or not, I'm just saying what was said. Taking that into account, I'm going to do it this way. I am going to award judgment to the plaintiff, the monetary part in the amount of $48,691.40. I am going to order that the $26,125 is to be paid to the plaintiff. The resulting balance, I'm going to indicate, cannot be that no collection proceedings regarding that amount can begin against the wards until May 31st. I'm picking that date to give them time to figure out if they have other remedies regarding that balance and give them time to sort that out. Should they seek to get counsel? Should they seek to go to the bar? Whatever they may wish to do. So I'm giving that time frame. I am going to order that an order of eviction will not issue, can issue April 30th. I'm going to give additional time for to vacate the premises. You can have until, if you get out the 10th, that's fine, but they can't do anything until the 30th. I'm going to give you the month of April to get out.
Okay, yes. It is what it is, but I don't know that I'll have the money to pay the lease the beginning of April.
No, I am not going to order that the $5,500 for April be paid.
Okay, so no payments,
no payments for April. March is already in, right?
So no additional payments at the conclusion of this hearing, period.
Provided you vacate the premises by April 30th. If you're out of the premises May 1, you owe April.
Okay, so no additional lease payments, period. Unless I don't leave.
Right. If you're not out in April, then you need to pay the monthly. You have to pay April and then the subsequent May month.
Okay.
So you'll have to pay 11,000.
Okay. And the 26,125 is the number that you came up with that I paid into the court's escrow.
That is the amount we have in escrow.
Okay. And
That's
so the
paid over to the plaintiff.
what we're still trying to figure out now, will my $7,500 security deposit come out of that balance? So would I pay it?
I typically do not deal in a landlord tenant proceeding because there's a whole nother section of statutes that apply to security deposits. I don't deal with nor take into account that. Since I will say this amount, since the amount of these amounts are rent under the Security Deposit Act, he can take that 7,500 and apply it to whatever rents due. So theoretically, it would go against us in any event.
It should go against then.
Well,
money.
ma'am, what did I just say? I said basically the framework of the Security Deposit Act is that I am not ruling that.
Okay.
Because I don't deal with the security deposit because you have not vacated the premises. All right. The other thing, one last thing is that the hearing, Ms. Tobe's hearing, I'm going to move that from the 17th to the 18th at 9 a.m. at a special time. I do not need the parties here currently present because I don't know that you have an interest in it. I will indicate to counsel, as I had said at the last proceeding, the amount that I had set on bond on that was to cover attorney fees that were related to the delays on that. If you would, so that you do not have to appear at that hearing, if you could submit a billing to my office that we can just hold so that I at least have that figure in mind.
If I have an affidavit right here,
Fantastic.
it's current as of today. So if we don't show up in the next one, this should be sufficient.
All right, fantastic.
And I'll just let we have redacted invoices, or like see unredacted invoices. I highlighted the days. You'll see.
Got it.
But if you want to see the unredacted ones, have to provide that for in cameras.
All right. And I don't know that I'm going to need that because counsel, I think I trust you, and certainly I don't think your firm would allow you to give me something that wasn't right. So, all right. All right. Okay. Anything else?
What do I do next to, like, is this done? Do I have to,
This case is done. I've issued, it's done because I've issued the date that you can stay in the premises.
Okay.
I've also now ruled on the issue of liability with the monetary amounts that I've indicated.
Right, but I'll hear from them about that at some point.
I would imagine you.
Okay, so I don't need to do anything. Okay.
You don't need to do anything Ms. Ward, so that you understand what I'm doing. I'm not allowing them to take collection efforts as to that difference till May 30th, 31st of May. The reason I'm doing that is because, as I think I had indicated from the very beginning of this case, you may have claims as against Ms. Tobe.
Okay.
That can come in various forms. Okay. And so I'm not suggesting one or the other. I'm just giving you an opportunity to explore your options as to how you remedy this. Because here's the cold hard reality. You're going to be out an additional whatever amount unless somebody makes that up. But counsel's right. It's not the plaintiff's obligation to do that. It's going to be whatever you decide to explore that.
Okay.
Okay.
So is there going to be something signed and sent to me, or
counsel will prepare an order? Counsel for the plaintiff will prepare an order for the courts.
I'll get a copy, and so I'll know that it's done and I never have to see you again.
Well, thanks for saying it there. But I appreciate it. Yeah.
Okay.
Yeah, you guys don't have to come back.
Awesome.
All right?
One logistical question. Yes. Escrow amount. We need to take this up with, and clerk on what I need to do on my end, to get that transfer.
We can do it one of two ways.
You ordered it released to plaintiff, so this.
But it will be released to plaintiff's counsel.
For example,
Correct, it goes directly to counsel.
It goes directly to counsel. So my question is, since he's here, the only one that may not be able to be paid out is this new one, right?
So all the money is technically in Celine. So Celine has to release it and our money needs to go to Celine. So
got it.
I can.
Okay, so
I can let them.
You don't need it unless you wanted it today.
I don't necessarily think we need it today, but better sooner rather than later. And my always with both courthouses to get that accomplished as soon as possible.
What I'll have my staff do is try to expedite because it's here, right? And it's got to go there.
Yes, it both places, but I can email the senior.
No, but the new payment is here.
Yes, sir.
So the new payment, we've got to get over to 4 to get into their drawer or whatever that is. And then it can be sent out. So what I'll have my staff do is expedite that process and then expedite the other end for the release of the check to Euro.
Sure.
All right. So you don't have to do anything. We'll take care of it. If you don't see it, then call anybody but me because I don't deal with that. But all right. All right. Thank you, folks.
Thank you.
Thank you.
This is 11.
That's my 11.
Mm-hmm. Amy is no longer in Zoom. Miss Scott.
You guys are on. Mr. Thompson. He's in Zoom.
Kimball is no longer in Zoom. Miss Haddad was in Zoom and is for an adjournment. Would you have to do adjournment speaking whatever the rest is on the record?
So who's in?
Rania Haddad.
What about defendant?
No, when I indicated it was an in-person hearing, no.
But he didn't send us an appearance.
We had a limited.
We had a limited appearance, but not for trial in today's trial. Okay. Go ahead and let Miss Haddad in. All right. The court does call the case of Haverhill and Clark versus Jeffrey Thompson. Mr. Thompson, come on up to the podium. Miss Haddad, I think, is here.
Good morning, Your Honor.
Good morning. All right. State your name.
Hi, it's Jeff Thompson.
All right. This becomes a bit confusing because as I've said, as an in-person hearing, I get that was a resolution. There's a resolution to this matter. Is that correct, Mrs. Dunn?
There is, Your Honor. We have an executed conditional dismissal. There is an opposing counsel that took on this case as a limited scope representation for resolution purposes. He, I believe, was trying to log in. So I'm going to take full responsibility for the error today. I was on my way this morning. We had it on our schedule at 9 o'clock this morning, Judge, and the court's ROA reflected that. When I called the court to let them know I was going to be 10 minutes behind this morning because it's a little over an hour drive for me, I was told that it was at 11 o'clock. And so it kind of conflicted with some cases that I had. So I really do apologize for that. We do take the court's, policies very seriously. And I believe opposing counsel tried to reach out to his client. But since he is here, I guess we can, if the court would allow us to put the terms on the record, if the court would allow that.
I don't have a cell phone. I haven't had a cell phone.
What did you say, Mr.?
I don't have a cell phone. I don't have a cell phone. I haven't had a cell phone.
No. Okay. All right. I'm Mr. Dodd. I don't have. So I'm not sure of the status of Mr. Campbell vis-a-vis this case? I get what you're saying, that was for purposes of resolution, but
It's now back in the waiting room. Missing.
he's now back in the waiting room. All right, let him in. Let's see if we can get this accomplished today. Have you talked to Mr. Campbell recently?
No, we tried to connect last night, but Alex Henry talked to me last night for a little while, but he's not.
So you spoke to Alex Henry? Okay, did he explain to you that there was an agreement and that they'd be here on your behalf, or?
Told me that I had to be here to be in front of you.
Okay, he told you you had to be in front of me. Would
ask me to sign the paper.
He talked to you about the terms of an agreement or anything like that?
Not yet. Not
pardon?
Not by Andrew. No.
Okay, did anybody else? Did Mr. Campbell or anybody speak to you regarding that, or?
Not yet. No.
Okay, so counsel, here's what I'm going to do. I'm going to adjourn this out 1 week because well, where did he go?
No, he's still there.
I'm sorry,
Your Honor, I'm here. I apologize, Judge.
Not a problem. So what I'm going to do so that everything can be explained without explaining it on the record, I'm going to adjourn it out 1 week, and so that counsel can have an opportunity to speak with Mr. Thompson regarding the agreement case. All right.
Cool.
But you've indicated you don't have a cell phone.
No. I don't. With CMH is. I have to go there I have to be there by 12:30, but I had to give blood this morning. So they've been trying, but because of the other thing that you and I are working on, I don't know if it was official, so they couldn't do anything with me because they couldn't put me with a new case manager with Sarah Stewart.
Okay. So
I've been
I get you
the last couple of months.
So let me ask you this. If I adjourn this out a week so that you can talk to counsel, how are you going to get through to your attorney?
I'll have to call him.
You'll have.
No, I tried calling him a couple of times from CMH yesterday, but he had.
Okay, so
he had a meeting yesterday, and then he had.
No, that's fine. I just want to make sure you guys have an opportunity to do that. So
it's been nice.
You're going to get to CMH at some point. That's where you call from when you. Yeah. Okay, no, that's fair. That's fair. Okay, so at some point you're going to get to CMH. You're going to get through to Mr. Campbell. Mm-hmm. He'll explain to you what's going on, and then we can see you next week.
Okay.
How's that sound?
Okay.
All right. And counsel, if everything is done and all the documents signed, you can appear via Zoom. Although I'd like to make Mr. Dodd drive all the way out here. I'm not going to have her do that.
Judge, I would make the drive out there any day. It was just, I took full responsibility for the error this morning.
No, it's not a problem. It's just that Mr. Campbell, I saw the appearance. I thought it was for Mr. Henry. But I saw the appearance, but it said everything up to trial. Mm-hmm. And then next thing you know, so it was a bit confusing to me, but I'm glad I got everybody here. Yes. And so what I'll allow everybody to appear via Zoom. If you don't, Mr. Thompson, if you don't have access to Zoom, just come down. All right, we'll be here, and then we'll do it that way.
Okay.
Fair enough, everybody?
Excellent, Judge. We really, truly appreciate it.
Thank you, Judge.
Thank you. You take care. Take care, Mr.
Have a nice day. Thank you.
Thank you, Judge.
Same. So we'll just adjourn this out to 17. I don't have a pen. I don't know.
All right, that's fine.
I'm in recess. All right, 14 A's in recess.
That's fine.
I'm in recess. All right, 14 A's in recess.
Outpatient programs that could be available to them.
Not that I can install right now.
There's nothing that they can do, like ISF or some type of program to say, hey, let me try to straighten you out, give you some skills, give you some opportunities one last time?
Maybe ISF for like cognitive.
I mean, in-house, it has to be something intense, would you agree?
Yes.
I have nothing further to do.
Thank you. Just a couple questions. Sure. Ms. Malbrough, as Mr. Ross's probation officer, whether you were in direct supervision of him or taking over the file from another officer, have you had an opportunity to review the entirety of his file? And do you know?
I need you to speak,
Yes,
please.
And do you know that when the new offense occurred and which he has pled true to on June 13th of 2025, was he wearing a drug patch at the time?
Yes, ma'am.
And based on your review of those records, do you find that the drug patch at that time on that date showed that it tested positive for cocaine?
Yes.
And would that have also been an additional violation of his probation?
Yes.
And is that also an issue that was trying to be addressed both with the drug patch and with the underlying original probation?
Yes.
Do you also know or happen to know that the officer involved in the courtroom recall from the new evading has now been relocated to Dallas for the courtroom recall, the video that you had reviewed previously? Have you had an opportunity to briefly review those offensive chariots? And you know that to be a very egregious high-speed evading through all parts of Jefferson County?
Yes.
And would it be your recommendation to continue Mr. Ross on any kind of probation at this time, or he can be revoked by the court?
At this.
Okay.
Any other questions of this witness?
Witness, Judge.
Any other witnesses?
Just Mr. Ross.
Mr. Ross, raise your right hand the best you can. Do you swear from the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Go ahead.
Please, court, just for the record, state your name.
Kevin Ross.
And Kevin, state, the court needs to now decide what to do with you, right?
Yes,
Simple
sir.
terms. Send you to the penitentiary or possibly give you a second chance. What would you like this court to consider?
Give him a second chance.
Okay, well, what do you base that on?
Like ISF.
Okay, but what do you base that on? What good do you have to say that I possibly will succeed?
Got a job. When I get out, I got a job. 3 jobs lined up for when I get out.
No place to stay.
Got a house.
You have 2 parents that are very disappointed in you, but they're still supportive, correct?
Yes, sir.
One of them actually works for a prison system, don't they? Mom,
Yes, sir.
she knows what happens in there.
Yes, sir.
And has she ever indicated to you that you're not penitentiary material? That is that it's not a good place for you.
Yes, sir.
Well, tell me why, once this court gave you a second chance, that you decided that you wanted to go and get in a car and try to evade a DPS officer.
You reset, say it again.
Why did you make that decision after this court gave you a second chance to get behind the wheel of a car and try to, I guess, get away from a DPS officer? Why didn't you stop?
It was like I was I was the wrong place, wrong time. And I was.
Did you really think you could?
How were you? Hold on.
Well,
Think about your answers very carefully. What does being at the wrong place at the wrong time have to do with this insane chase that you went on? Insane. I mean, 127 miles an hour crazy. What does that have to do with being at the
I
wrong
was
place?
the wrong crowd at the wrong time. Like,
So the people in your car were the wrong crowd?
yeah, like I was just hanging with the wrong people.
And that's what made you run from the
When I stopped, they just were like, nah.
Okay.
It was just intense. Like I stopped for them and they looked at me and was like, nah, don't, not just
It just,
Because y'all were doing stuff you shouldn't have been doing in the car. Right?
no, man.
No?
I was coming from the house going to get something to eat.
Okay. Go ahead.
Are you asking this court to consider giving you a second chance at putting in you some type of program?
Yes, sir.
Is there anything else you'd like to tell the court?
Like like how she brought up the write-ups. I just was.
I'm gonna address that. Let's bring up the write-ups. You have 15 pages of write-ups. Why? Oh, there's another one. It's just on the
One's first, one's Ashley's.
Like the last few write-ups, like I defend. It was just defending myself.
The last write-up you got is because you were urinating on something outside at the jail.
No, man.
Am I wrong? Am I reading that wrong?
Well, you must have got the wrong person.
said you were urinating by a door by the rec yard on Hillside.
When this was.
Then walked
March
down the
10th.
sidewalk, observed you, in fact.
That's today. That's today.
What's
today? They must have got the wrong person.
So this morning at 6:40 this morning.
Yeah, they got the wrong person. I came out of the dome at 7:00, 7:02 on the dot. They woke me up late. She must have got whoever wrote it got the wrong person.
No, I'm gonna check on that. Go ahead though.
I just have comment in reference to the write-ups, Judge. I have no further questions of this witness.
All right, any questions, the witness? All right, go ahead.
Reference to the write-ups, Judge. I understand that there's a problem in jail. And I know the court is well aware of what's been going on there like this and talking abusively to the jailers, gambling, fighting. But I just like to, I know the court realizes that when you put 30 or 40 people that are accused of crimes, they're not the best people probably in the world, and you put them all in a dorm and ask them just to sit there and not do anything, there's going to be problems. There's gambling, just like people gamble at their house, people do other things. I know that they're told not to. I know it's against the rules. Being disrespectful should not happen. I'm not here to tell you that. Fighting, I think that's probably a cause of everybody on top of each other, everybody living together in dorms. And it's just a fact of wherever you go, families fight between themselves. They fight. Now, is it right? No. He's in custody. He has to now come in front of this court and say, please give me probation, when you have to consider jail time and his actions in jail. And I know the court is well aware that it's a difficult situation for people, especially the type of people that are incarcerated, to all get along and be friendly and sing songs together. I'm not trying to be funny, Judge. So I would ask that you take that in consideration once the incident reports. Calling the jailers names, being disrespectful. There is no need for that. And I would tell you that he is wrong, and he apologized for that when I talked to him, to the officer. But that's my comment on these jail things, Judge.
Give me just a second.
Ms. Malvina, Judge, I don't really feel the need to tell the court anything that you probably, I know you already know. This wasn't his second chance. This was his third chance. Now he's asking for about a fourth chance. He squandered those opportunities, and then while awaiting your sentence, he cannot behave. I don't think that there's any reason to sentence him to anything less than the 8 years. The court previously rejected a 5-year offer. And I think obviously that was a wise decision, and I asked for $8.
Judge, there's no excuse for what he did. It could have turned out very bad, doing 100+ miles an hour. Thank God it was at night with not much traffic, because he could have, or he could have lost control of the car. He does have some.
He
mental
did.
health-
He crashed.
No, he didn't crash.
Crashed out at 2225 Salisbury.
I saw it in the park in front of the house. He actually ran into the house.
And climbed up into the ceiling and had to be brought down at gunpoint.
He didn't crash. He drove home.
Okay. Mr. Ross, so what I'm looking at over here and reminding myself of, just because it's been a little bit, is several things. One, the underlying offense that you were placed on probation for in the first place, the evading arrest or detention with use of a vehicle, where you ran from the cops in a car, you did crash, and that's one.
This is today. If you want, we can terminate your supervision today, and I can unsuccessfully terminate you from ILC and impose a sentence, which includes a local jail time of, is it what's our jail days?
35 days.
Of 35 days, and you can be done with us. Alternatively, if you want to continue on supervision, if you can behave yourself and give me clean drug tests for the next 90 days, I'll successfully terminate your ILC. Do you understand that?
Yes, sir.
All right, that's the second part of it. The first part of it is whether or not, Mr. Brenner, do we want to have a contested hearing in this?
Your Honor, based on what the court just conveyed or what I conveyed to my client, we are prepared to go ahead and admit to the violation here today. My client would like to remain on ILC supervision for that 90-day period.
All right, do you admit or do you deny that you violated the terms of your supervision?
Yes, sir.
All right, based upon your admission, I find you have violated the terms of ILC. We have 35 days of jail time credit. Mr. View, anything from the state?
No, Your Honor.
Officer Bridgman?
Nothing else, Your Honor.
Mr. Brenner?
Nothing further, Your Honor.
Anything you want to tell me, Ms. Mason Strauss?
No, sir. I thank you. I just like to be done with this and do what else I need to do, finish my supervision.
All right, well, we're not done with it today. We got some more work to do. So I am going to continue you on intervention in lieu of conviction. And the idea is if you can behave yourself for the next 90 days and report and submit clean drug tests, we're going to successfully terminate you from intervention in lieu of conviction after that 90-day period.
Yes, sir.
Anything else?
No, Your Honor.
All right, I'm going to give you credit for the 35 days you've already done. You'll be released from jail today.
Yes, sir.
All right, good luck to you.
I'm sorry.
That wasn't anything, when we were here an hour ago, that was not anything that you.
I think with another vehicle, but anyway, you had a gun on you. And so then you get probation. And not, 5 months later, something like that. You're out while you're on probation at almost 1 o'clock in the morning in a car with 3 other people. One's a juvenile. There's marijuana in the car. There's an AR pistol in the car. And you run starting at 9th Street and 9th Avenue and 41st Street and end up with DPS, Jefferson County, Port Arthur, Groves, and Nederland all having to be involved in a high-speed chase that went, you were blacking out, you're turning your lights off. I mean, it's just crazy. You're already on probation for the same thing. And then you do it, and you do it really bigger this time with a gun hanging out with the wrong people. You are the wrong person, right? You can't say that you're hanging around with the wrong people when you keep being a part of that. It's not their fault. You were driving. You were out with them with marijuana and guns doing who knows what. Then you get in our jail and act like an idiot in our jail. And I don't agree with Mr. Burbank that just because you're in jail and it's a difficult situation, that there should be some kudos given because there's a bunch of guys living together and you can't get along. You are getting along. You're gambling. You are getting, I mean, it's just the disrespect, the not following the rules just shows you got your opportunity on probation, chance one. You've already had an unlawful carrying a weapon misdemeanor that you were given 6 months deferred probation for. You've already had a resisting arrest back in 23 that you got a probation for. A possession of a dangerous drug, you got a probation for. That one's pending now, a motion to revoke. So you've been given those opportunities. Then you get an opportunity on a felony, 2 felonies, and now you've got another felony. So continuing probation, it's not.
I can make an announcement.
Can he make a comment?
No, hold on just a second. Okay. So I've just received verification of the incident this morning from the supervisor that they're saying that it was in fact Mr. Ross who was written up this morning for the infraction that I already talked about. All right, Mr. Ross. What do you want to say?
About the write-up situation that you just said. The write-up that I get in the jailhouse, it don't be because I gamble. Like they play stuff at the table, and I'm just at the table watching.
Right.
Everybody just get wrote up. We in the day room. It's the day room.
Right.
So everybody that's in the day room watching.
Like you were in the car and you're just around all the bad people. It's always somebody else's.
Then the disrespect, every write-up they write, they put disrespect stuff. You only got to say nothing. Like when I try to plead with the write-ups with the gambling, I plead to them, like, look, it wasn't me gambling. They agree to it, and then they still put it in the system. Once it's in the system, they can't take it out.
So when they put a write-up that you're disrespectful, they don't just put the word disrespectful. They put the specific stuff that was said.
Yeah.
Yeah.
So when we got wrote up, I go to the desk, tell them like, look, that wasn't me gambling.
And you said it like that, really respectful, like you're talking to me. That's how you talk.
I said, that wasn't me gambling. They like, nah, we're not trying to hit it. You was in the group watching, so you're getting wrote up with them.
Mm-hmm.
But we're in the day room together.
Okay.
The disrespect, the wrote up that you read to me last time when he said I called him a B word.
Mm-hmm.
The lieutenant verified, ran the camera back and saw that I didn't tell him that.
Okay.
And dismissed the write-up.
Okay. So if you keep getting in trouble for sitting around watching other people gamble, and it doesn't happen just one time, but you keep getting written up for it, at what point do you learn to go sit somewhere else?
When it's the day room, we 50 deep in the day room. We're watching TV, getting on the phone.
Not everybody that comes in front of me is getting in trouble for gambling. There's somewhere else to go to not get yourself in trouble when you're looking at going to prison.
Try to sit on my bunk, fights come.
Okay.
I've been
All right. At this time, Mr. Ross, and cause numbers and cause number 25 DCCR 1310, which is the new case. I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. Going to sentence you to a term of 7 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 24 DCCR 1198, find sufficient evidence to find counts. Sorry, get back to that.
1, 2, 6, and 7, Your Honor.
Counts 1, 2, 6, and 7. You entered those pleas freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. And sentence you to a term of 7 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Cause number 24 DCCR 1199. Also find that you entered your pleas of true to counts 1, 2, 6, and 7 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of possession of a deadly weapon in an institution, penal institution. Sentence you to a term of 7 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will all run concurrently, which means together at the same time. I've handed you the trial court certifications. This shows that these were agreements I followed, so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Burbank. Good luck to you, sir. You can go back with the bailiff.
That's all I had.
Thank you, Mr. Burbank. Yes, sir.
I'll get you a check.
Jesse Griffin, Ms. Coffin. Okay, you can tell, we'll hold the, he's going to get reset for an examination. We'll get that examination taken care of.
Okay, thank you, Your Honor.
Yes, ma'am. Thank you.
May I be excused?
Yes, ma'am.
Thank you. Thank you.
Mr. Eckhart, on Robert Trahan.
Yes, Judge, we have to fill out the new rejection.
I've got, it looks like I've got 3 of them. No.
Yes, ma'am.
Yeah.
One, Judge.
Morning. Good morning, sir. You Robert Trahan and Mr. Trahan, and clause number 25 DCCR 1094. You're charged with the state jail felony offense of unauthorized use of a vehicle from June 3rd of 2025. The indictment alleges that you were previously convicted of accident involving injury or death, a special degree felony, October 16th of 2017. And after that was final, you were convicted of evading arrest or detention with the use of a vehicle, October 17th of 2022, and also possession of a controlled substance, October 17th of 2022. And so that special degree is considered, have y'all done any research on how that's considered as far as enhancement purposes?
I believe it's considered a third for enhancement purposes. Third, I've got him at 2 to 20. Because
No, just the, right, if that's considered a third or more,
It's not
then it would be
considered.
2 to 20. I just need to know of the special degree, you think it's considered a third?
I believe so.
Which
Just
would
because
make,
the sentence was 3 years, I believe, before 1 or 2. I'm confused.
so in the
If it's
indictment,
third degree,
one of the prior felonies that are listed as enhancement is a special degree felony.
policy.
And so it's on one date in 2017. The other 2 are on the same date. And so in order for it to enhance, I need to make sure that it's considered a third or more and not a state jail
Now I understand.
for punishment purposes. And so I want to make sure we are all on the same page. What is the range of punishment for that?
Judge.
Degree. I haven't had one like this in a while, so.
It's they amend that statute to
be different now than what it was back then, and that's why it was a special degree in the first place.
Gotta know what it was.
It made the minimum.
Actually, Judge, you know what? I have my criminal history here. Let's see what it.
Y'all do this. Let me hold it for
Yeah.
a minute and just double check what that range of punishment was in 2017.
Okay.
Because that would be the law that would be followed. And if y'all need, I have old books. So let's do that first and then we'll figure it out. I'll just hold the paperwork.
One of those minimum maxes hollow is. It's on page 3. Now you can get right. So we'll make it happen.
Okay, thank you.
They got 3.
Did you hear that?
It was greater than such a margin or that.
Mr. Radford?
Yes, ma'am.
On Joseph Freeman.
Morning, Justice.
Morning.
Mr. Freeman wants a trial.
Has there been any change?
Well,
Let's see what the previous.
Work it out by year. His convictions for the aggravated robbery were affirmed. He wants to write a bit.
Okay.
You representing the state?
No.
I was about to say, you're on the wrong side. This is Joseph Freeman.
I was gonna borrow one of those books when you get a chance.
Let's see, we need 20. That should be, it's not 15, 16.
Yes, ma'am.
All right, sir, you Joseph Freeman?
Yes, ma'am.
And in cause number 24, DCCR 0348, Mr. Freeman is charged with murder. And in cause number 21, 38728, charged with deadly conduct, discharging a firearm. And what is the announcement?
Judge, Mr. Freeman would like a trial. I visited with him last week. He says he wants to go to trial on the murder case. Is that correct, Mr. Freeman?
Yes, yes, ma'am. Yeah.
And so it looks like, has there been any offer?
Yes, Judge, the state offered to run a 60-year sentence concurrent with the 60 years he recently received from the court in the MTRP.
It wasn't an MTRP, it was 2 unagreed pleas.
Unagreed, you're right. It
The
was
ag robberies.
It was unagreed.
Can you do this real quick, just so that I have a paper trail in my file to show why we get it there? If you will do a plea bargain
I think
rejection.
there's one in there already. He rejected 40.
Well, let's put what the new offer is now that the underlying case has been affirmed. And so that is done. Let's do a new one, if you don't mind, real quick. And that way it shows what the offer is now. Yeah, it's on the tablet. I'll hold it for a minute while y'all get that taken care of, please. Thank you.
Judge, I would ask that the court admonish, wait.
I will when you get that done.
Okay, all right.
Yes, sir. I'll go through the whole thing. Thank you.
Can you, yeah.
I just already asked if it was me.
It's not my day.
Ms. Perazzo, it's not. We can't use that excuse today. It's just Monday. Where's our guy from yesterday? It's just Monday. It is. We haven't seen, what about Mr. Reynolds? Have you seen Mr. Reynolds? That's okay. Let's see. What about, Mr. Parker? Okay, that's good. I'll let them. And Mr. Lewis, are you still working on some? Or are you?
Oh, I'm
caught?
really just I know that thing that he doesn't talk over.
I'm sorry.
I think Miss Marfina want to talk on one, so we need to hold.
I'll hold it for a second. Do y'all want to talk on that one real quick? Go ahead. I'd rather get it all. They also can't Nations.
What?
Good morning, you're Mark Garcia. And Mr. Garcia, calls number 25 DCCR 0120. You were previously in court. You entered a plea of guilty to theft of material, aluminum, bronze, copper, or brass, a state jail felony, and that was a cap of 16 months in the state jail prison. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have to.
I do, Judge. Are there any additions or corrections?
Yes.
Explanations?
Yes, there is one issue that we would like to address regarding his statement.
Okay.
And Judge, that was in regards to his description of what happened as far as when he talks about them not stealing the copper. I think there was more of an issue of course, him not admitting that they were caught in the act. This was something that was after the fact, they was stealing the truck. He understands, how that may have sounded the way he expressed himself, and he totally takes responsibility for it.
So, Mr. Garcia, you said specifically in quotes, we did not steal anything from there.
We didn't, but we were caught there. We shouldn't have been there in the first place. I accept responsibility for what we were doing.
Well, what were you doing? What are you accepting responsibility for?
We showed up to look at the site. We were supposed to check it out. And that's when the cops showed up. I wasn't even in the, I was there, I was in the truck when the cops pulled up, but I thought we were there on a job. So thought we were supposed to be working, we were supposed to win, but we hadn't yet. But I accept responsibility for what we're there to do. You know what I mean?
I don't know what you mean. That's why I'm asking you, because you're saying you were there in absolutely legit reason. And there was material in the back of your. Here's the thing. Now's the time not to gloss over it. Okay. Either you did it or you didn't do it.
Yes, ma'am, I did. That's why, but
that's not what you're saying. You're saying you went there to do a job and the cops pulled up and y'all just got in trouble and you don't know why.
For 10 minutes. I don't know how to put it in words. I did what I'm accused of being doing. I don't know how else to word it. She asked me to describe the situation. I did.
You said we did not steal anything from there. So did you or did you not steal?
I did.
Okay. So that's not what you just told me.
I don't know how else to word it. I hadn't gone in yet. We hadn't, but I don't say.
But the stuff was in, you had cut copper, a reciprocating saw, drills and tools in the immediate area, in addition to multiple bundles of copper in the back of the truck. So how, I don't still understand. Did you steal the copper or not?
Yes, ma'am.
So now let's go to your criminal history and the fact that this isn't your first time to do this. You've got 5 prior felony convictions. You've received the max of 2 years state jail on 2 of them. 1, possession of a controlled substance and fraudulent use or possession of identifying information. You've received a 1-year state jail on theft of material. You've received a 2-year term on possession of a controlled substance. What all that means to me is that the deal that you received going on count 1 only, you could have been looking at 2 to 10 instead of just a state jail. And I don't agree. I think after seeing this, Ms. Malfino, is there something else that you either did or didn't know that would go into the state's position on that offer?
Judge, only that in my review of those priors, there were two state jails that did not need to be sequential. So I would agree that it could be a 3rd degree. I totally understand the court's confusion with something less than is what the 2 years that he has already received, and if we need to revisit that under a third degree. I think
There's no facts or issue. Is there any, I mean, I guess any underlying facts or issues with the case that,
Not particularly, Judge. I mean, I know some of the people that run the AT&T, and I know this is a very menacing type of offense that then leads everyone else's bill to increase because we're all paying for what they're doing, but nothing particular because of this offense, Judge.
okay, then I'm not going to accept that, that agreement. It doesn't make any sense to get rewarded for continuing bad behavior if there's not some underlying other issue.
And Judge, just to kind of point out there, mitigating circumstances for us. Mr. Garcia, he was dealing with a drug habit. That even is why he's in custody right now from testing positive when he came into court. He has been struggling with that, but he has done some things or to try to move himself from the surroundings he was in, even while the case was pending.
I appreciate all that, but there doesn't seem any reason for me at all to agree to a 16-month sentence when this is his 6th felony offense, and it's the same type of offense. And the last time he was enhanced, or it was at least a 2-year in prison, in TDC, not state jail. He's looking at 2 to 10 if he went to a jury, and I don't think 16 months is appropriate at all. I don't think that's what a jury in our community would think was appropriate for someone who continues to, y'all go talk about it if you want to. I can reset it and you guys can kind of renegotiate and look at it and let me know. But at this point, I'm going to reject that offer. Thank you. Perry Heard, Mr. Lewis.
Very heard.
Yeah. And
There's no paperwork on this one.
No, ma'am, Judge. Evident there's some questions. There was some questions regarding this criminal history.
Good morning. Are you Perry Heard Jr.?
Right.
Yes or no, please?
Yes.
Stand up. Thank you. And Mr. Heard is charged with harassment of a public servant from November 24th of 2025. And what is the announcement?
Judge, I've met with Mr. Heard and I've also talked with Mr. Smith in regards to this matter. And evidently there's some questions in regards to his criminal history.
Okay.
That I need to speak with Mr. Heard about. I mean, I was under the impression that there wasn't any additional criminal history that we were dealing with other than this, and then there is, especially some out of county stuff.
Okay.
So I need to go over there with Mr. Heard to check those judgments.
Okay. I know there's one listed in the indictment, but there's more than that.
Right.
Okay. All right. So I'm going to reset the case. That'll give Mr. Lewis some time to get all of that information regarding criminal history so that you know what your possible consequences are, what your options are. We'll get an announcement at the next time date. You can go back to the court, the bailiff. Mr. Radford, we'll take care of Joseph Freeman.
Yes, ma'am. Freeman.
Who's?
Karen.
Yes, please.
Go for it.
Okay, all right, Mr. Freeman, in cause number 24, DC, hold on, so let me get to it. DCCR 0348, you're charged with a first-degree felony offensive murder. That's from March 27th of 2022. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 5 years and up to 99 years or life in prison. Do you understand?
Well,
And then in cause number 2138728, you're charged with deadly conduct, discharging a firearm at individuals from October 22nd of 2021 And that's a third-degree felony, which means the punishment range, if you're found guilty, is between 2 years and up to 10 years in prison. Do you understand?
Yes, Lord.
I have plea bargain rejections in each of those cases that shows that the district attorney's office has made offers if you wanted to enter pleas of guilty. In the murder case for a 60-year sentence that would run concurrently with the aggravated robbery sentence that you've already received. You have every right to reject that, go to trial, have a jury determine if you're guilty or not and what your punishment is. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
Yes, ma'am.
Do you want to reject that offer and have your case set for trial?
Yes, ma'am.
Judge, I would ask the court to admonish him about consecutive sentences.
So because of that prior conviction, I guess I have the legal question of they can be run consecutive, even though weren't they out of the same?
No, ma'am.
They were not. They were different offenses, and that was a previous offense. The date on the aggravated robbery was prior to the murder.
See, I got the indictment right here, Judge. Yeah.
I mean, I guess the conviction's prior. But does it require the offense?
Not for I mean, just different offense dates as well.
Is that your understanding as well?
That's not a, yes.
So I do want to make sure you understand.
Criminal episode.
That's right.
Okay. That because the aggravated robbery and the murder were different criminal episodes, different dates, different allegations, that if you're found guilty in the murder case by a jury, and you're sentenced to some number of years, the state can then and will, I'm sure, ask that I run any sentence that you receive consecutively, which means stacked on top of each other instead of concurrently like they're offering now. It would be up to me after I hear all of the evidence. I want to make sure you understand that that is also a consequence that you could be facing if you're found guilty by a jury. And do you understand that as well?
Yes, ma'am.
And do you still want to reject any offer and go forward with the trial?
Yes, ma'am.
Okay, then we'll get your case set. And I guess the deadly conduct will just, it was, what was part of that? I don't see a rejection. Was it just either to run concurrent or to be dismissed?
It would be run concurrent or dismissed.
Okay.
The focus is on the mother.
All right, so I will set the murder for trial. I do want to make sure, Mr. Freeman, that you understand that after today, I will not accept any plea agreements. The cases obviously are very old, and part of that is because we handled the other ones and there's been appeal, and so some time has passed. And so your case is going to get bumped up pretty quickly for the top of the trial list. And so if there's any other negotiations, I need to know about it well before the trial or the pretrial date. But unless there's new information that comes to light for your attorney or the state's attorney, I will not accept any plea agreements. Do you understand?
Yes, ma'am.
All right, you can go back with the bailiff.
Thank you, Judge.
Yes, sir. Thank you. Yeah. Let's see, Dominique Lee, Mr. Lewis.
Maybe excuse me.
Yes, thank you. Good morning. Are you Dominique Lee? Good. And you're Dominique Lee?
Yes, ma'am.
And Mr. Lee is charged with criminal mischief and cause number 25 DCCR 1784. And what is the announcement?
Judge, we've actually got a new offer from the state in regards to this matter. There is one other piece of discovery that I did receive that I do need to go and watch with my client.
Okay.
It is some video of the actual, initially we had still pictures, now we have the actual video.
Okay.
So I'm gonna go and look over that with him and go over that offer with him. And I think, we'll probably get it resolved by the next
Sure.
day.
All right. I will just reset a normal reset. Mr. Lewis will be out to see you soon with all that information, and then we'll get an announcement at the next court date.
All right.
All right. You go back with the bailiff. Eric Segrest, Mr. Lewis. Mr. Smith, Eric Segrest, the bond hearing. Good morning. Are you Eric Segrist?
Yes, ma'am.
And Mr. Segrist is charged in cause number 25, DCCR 1836 with burglary of a habitation. Mr. Lewis has filed a motion asking that I reduce the bond, which is currently set at $50,000. Mr. Lewis, you may proceed. Mr. Segrist, best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you. Go ahead, Mr. Lewis.
Mr. Seacrest, we used to take your full name for the record.
Eric Martin Segrist Jr.
Okay, at the time that you were arrested, were you employed at that time?
I actually I had a job interview for Walmart the next day and I missed it.
But you, at that time, you weren't working?
No, sir.
Okay, no, sir. Up until the time that you were arrested, were you able to have any money saved or anything like that that you could use to forge your bond?
No, sir. My sister was planning on helping me out.
Okay, so any help would come from your family?
My family, yes, sir.
Okay, now the employment opportunity that you did speak of, is that still available to you?
Yeah, as soon as I go home. Like she actually asked about me yesterday morning. And I have a neighbor in my neighborhood, and she has like a bunch of overgrown trees, and she was asking my sister if I could come over there and clear out all the stuff, and she was going to pay me to help bond out.
And if you're able to make bond, where would you be living?
At 6161 House Street in Groves, Texas.
Okay, now is that the same residence as the complainant in this case?
No. That's my sister's house.
Okay. So you will be able to handle any type of bond conditions, for example, like no contact with the victim, things of that nature?
Absolutely, and the job is walking distance from my house. Like it'll take me 20 minutes to walk there, my house. And I just bought a brand new bicycle, so I could ride my bike straight to Walmart to go to work.
Okay. Now, as far as the bond amount, it's currently set at $50,000. About how much do you think your family could afford to try to help bond you out?
Well, I'd say because I have another bond that's 10,000, and so probably around that area, so she can get a better deal with the bondsman, like around 10,000.
So you're asking for a bond you said it's 10,000 on this case, but ultimately you would have a bond obligation of approximately $20,000.
Yes, sir.
What's the other bond for?
It's for an assault case, I believe, Judge.
I missed the misdemeanor.
Yes,
assault.
misdemeanor assault case.
Any questions?
No questions, Judge.
Any other witnesses?
Oh, no, Judge.
All right, Mr. Smith, what is the state's position?
Judge, this was a case where he broke into this house, sliced his arm very badly on the window, trying to break through the window, assaulted the victim in the case, stole her phone, and ran away after the police had been called. They were able to find him because they used to track my iPhone. It's family violence. They were living together at the time. We have had contact with her. She came in and talked to me last week, or before last, on this. So we would be opposed to a bond eviction.
And just for the record, I'm taking judicial notice of the court's file. It does include the probable cause affidavit, and so I have reviewed that as well. Anything else, Mr. Lewis?
Well, Judge, this is the one that we, of course, reset from recently when the state was looking to hear from the complainant in this matter. And I think, like Mr. Smith said, they did have a chance to talk to her. And even from my understanding from that conversation of what we're dealing with is a situation where it's still kind of shaky as far as factually of what went on between him and her that evening. It is something that he definitely wants to pursue. I'm not just going to say a trial, but pursue this matter further as far as trying to get it resolved. He does have plans to hire his own attorney, who is Mr. Parker. He's gone now, but that's initially who was the family's going to try to help have hired for him. So they're looking to bond him out and hire his own attorney as they proceed with this matter. We're just asking for him to have that opportunity. That way he can get back to work and help pay for that on his own and not be situated with any burden or obligation on his family moving forward.
Okay, at this time, taking into consideration the factors in Art 17.15, I am going to find that it is not in the best interest to grant the motion to reduce the bond. I'm going to deny that. The underlying facts, the testimony today. And so what we'll do is get it set as quickly as possible. If the family hires Mr. Parker, great. If not, then Mr. Lewis obviously will remain as your attorney and move forward with going through discovery, and we'll get it set for an announcement and move forward as however you guys plan to at that time.
Okay.
Okay,
Thank
go back with the bailiff.
Garcia,
Sure.
could we get just a short reset on that? Mr. Lewis wanted to speak with the defendant's parents. I've tendered him 2 alternative offers.
Sure.
We can address with the court at the appropriate time.
We'll just do a reset on what Garcia normally said. Thank you, ma'am. Robert Trahan, Mr. Eckhart.
Yes, ma'am.
We go, Judge.
Thank you.
This is the judgment. So it is not, the indictment in the cases does not allege serious bodily injury. So it is just the generic accident involving injury, which I think puts you under 550-21 under the last, under the last, the general punishment range. Which is
up to 5 years.
Yes, ma'am. And so that actually hasn't been changed at all. That's how it currently reads as well. And my understanding is that qualifies as a punishable enhancing offense for purposes of habitual offender status.
Okay. All right. You agree, Mr. Coleman?
Yes, Your Honor.
Okay. Thank y'all for taking a look at that. Okay. So what that means, let's go back then, Mr. Trahan. In 25 DCCR 1094, you're charged with that state jail felony offense of unauthorized use of a vehicle. And in that case, you've got the prior offenses that we went that I've already gone over, which are 3, 2 on the same date, but then the other one, they are consecutive. And what that means is if you go to trial in that case and you're found guilty and those prior convictions are true, the range of punishment would be that of a second-degree felony, which is between 2 years and up to 20 years. Do you understand? Answer out loud, please.
Yes, ma'am.
And then cause number 25 DCCR 1317. You're charged with the state jail felony offense of possession of a controlled substance from December 28th of 2024. The indictment alleges those same prior offenses. So again, what that means is if you're found guilty in this case and those prior convictions are true, the range of punishment would be that of a second-degree felony, which is between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
And then finally, in cause number 25 DCCR 1536, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from August 20th of 2025. And it alleges those same prior felony convictions. And in that case, what that means is that if you go to trial and you're found guilty, the range of punishment would be that of a habitual offender, which is a minimum of 25 years in prison, up to 99 years or life in prison. Do you understand?
Yes, ma'am.
And in all of those cases, I have here on the computer some documents, some plea bargain rejections that you've signed with Mr. Eckhart that show that the state has made offers if he wanted to enter pleas of guilty. And those offers are for, in all of the cases, in the first two to go on all of the counts, and the last one, the habitual, to go on count one only, for 7-year terms in all three of those cases that would run concurrently, which means together at the same time. You have every right to reject that and have all of your cases set for trial. I want to make sure you understand what the possible consequences are if you go to trial and what your options are. Do you understand all of that?
Yes, ma'am.
And you want to reject those offers and have your cases set for trial?
Correct.
Okay. And I'm assuming, Mr. Eckhart, you've received all the discovery.
You have, Judge. We've got the media, we've got the discovery, and we've gone over Mr. Coleman's offer thoroughly.
Okay. And y'all, with regard to that evading any video, you've gone over that with, had an opportunity to go over that with Mr. Trahan?
Yes, ma'am.
Okay. Then, Mr. Trahan, I want to make sure you understand, Mr. Coleman, is there any reason to believe that there's any other reason or additional evidence that would change your mind on that offer?
Not at all, Judge. In fact, the offer, Mr. Eckhart has done a good job at getting it to where it is, Judge, and I have no reason to believe it'll change.
So, Mr. Trahan, I want to make sure you understand, you have every right, obviously, to have a jury determine everything in your cases, that after today, I will not accept this plea agreement after today. Do you understand?
Yeah, do you have all the evidence from the people who testified and
So I don't,
statement, victim statements?
so you have, I don't have anything. That's not my part of the job. So what Mr. Coleman has, he's required to turn over to Mr. Eckhart. I'm sure he has turned over every single thing he has. Mr. Eckhart has all of that, gone over what they have with you. And then any other evidence is just evidence at trial that could potentially come out. But I'm sure any discovery, written discovery, and media, videos and things like that, pictures, have been turned over, and Mr. Eckhart's gone over that with you, correct?
Well, yes, but also I barely have enough time on Sunday just to talk to my family about anything that had to do with signing for anything. So I definitely declined it because I don't have time to talk to nobody about nothing before I could even see if I could, because they were talking about hiring a lawyer to begin with. So that's what she had just told me on the phones. It was just, I really haven't had time to do anything. It was just like a forced play, like a quick thing. And I was just,
well,
I told him that the court will let him hire a lawyer if he so chooses, but they're not going to change his date for his trial. Based on that, he's going to have to do so before.
Sure. Well, a couple of things. One, obviously, if you want to hire your own attorney or your family does, that's fine. But I do want to make sure you understand that the offer today is the offer, no matter who your attorney is. So they're not going to come in and get a different offer from Mr. Coleman.
Yeah.
So that is what it is. If you would like, I will reset your case 1 week to visit with whoever you want to and make your final determination before you go to trial. This is obviously very serious. I'm not trying to talk you into or out of anything, but if you're found guilty, a minimum of 25 years compared to 7 years is obviously a very big difference. You've had an opportunity to review the discovery that Mr. Eckhart has. That's not going to change. Whatever the video is, whatever the evidence is, it is for whoever gets your case. Your family hasn't seen all that, but you have. You have 1 week, Mr. Coleman, if you will indulge to leave that on the table for 1 week. I'll reset your case 1 week. We will get an announcement one way or the other next week.
so I can get the discovery and be able to look at it myself.
So here's the thing. There's specific laws that don't allow defense attorneys to just hand everything to their clients. So he can go over it all with you. You can look at it, but for you to have it in your possession is not allowed. So Mr. Eckhart, if you would go back one time this week, go over everything again with Mr. Trahan, make sure he sees and reads everything, then we will get an announcement next week, and that'll be it. Okay.
Okay, what was I saying? What did we bring that?
Yeah. Anna, so I sent those to you, the projections. You can just kind of hang on to them. If they're going to be the same next week, we don't have to redo that. Mr. Parker, you've got Kenneth Barthol.
Ma'am.
Kenneth Parker.
One, two.
I got one that may be a problem, not this one.
All right, so we're going on 3. This is like 2. Good morning. Are you Kenneth Barthol?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment in each case?
Your Honor.
I am going to first also, I think we've probably done it, but just to make it clear, I'll take judicial notice of the court's file in each of the cases. Mr. Barthol was evaluated by Dr. Capon for competency to stand trial. And we received an evaluation and report back on November 3rd of 2025. The finding in that is that Mr. Barthol was competent to stand trial. Is there any other evidence with regard to competency today?
No, Your Honor.
No, Your Honor.
All right, then based on that, I will find that Mr. Barthol is competent to stand trial and proceed. So, Mr. Barthol, in cause number 25, DCCR 1207, you're charged with a third-degree felony offense of obstruction or retaliation from July 19th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
No.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
And then in cause number 25, DCCR. That's a state jail. We're going on count one only in the state jail case.
So is that?
1752.
Yes, Your Honor.
Give me just a minute. In 25 DCCR 1752, the state has elected to proceed on count one only. It alleges you committed the state jail felony offense of possession of a controlled substance from January 11th of 2025. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you actually did what they charged you with?
Yes, ma'am.
And then lastly, we have cause number 25 DCCR 0878. And in that case, you're charged with a third-degree felony offense of obstruction or retaliation from May 24th of 2025. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes, ma'am.
In all three cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand?
Yes, ma'am.
And do you understand if I follow the agreements that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1 in each case.
Objection.
It's admitted. Is there any, again, there's no other evidence about competency. All right, Mr. Barthol, I'm going to find in all three of your cases that you entered your pleas of guilty freely and voluntarily. Find, again, you're mentally competent. You understand the nature and the consequences of those pleas. In cause number 25, DCCR 1752, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of possession of a controlled substance. Sentence you in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 25, DCCR 1207, Also find that you enter your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of obstruction or retaliation, sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then finally, in clause number 25, DCCR 0878, also find that you entered your plea freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of obstruction or retaliation, sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to go back real quick because I think I failed to mention, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
Okay. These cases will run concurrently, which means together at the same time. I will sign dismissals as part of this agreement in cause numbers 25 DCCR 1206 and 25 DCCR 1208. I'm handing you in each of your cases the trial court certifications. That shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff. Victor Campbell, Mr. Parker. Okay.
He knows a lot better than me. He's already in prison for murder. Out of another county.
But he signed it, but he.
Yes, I'm just saying.
Okay.
I don't know how he
It could be a.
He wanted to say no contest. He wanted to. Explain the law was to you. Oh, yeah. Did Philip sign them? I'm sorry, Judge. You were thinking police laws, yeah.
Good morning. Are you Victor Charles Campbell Jr.?
Yeah.
And Mr. Parker, will your client waive the formal reading of the indictment in each case?
Here you are.
And it looks like we are going in 21-36426 and 22-39050, correct?
There's also a dismissal in 305.
And are we going on all of the counts or?
No, not on. We need to go on, well, in 36426, he will need to be true to the one enhancement paragraph in the indictment.
Okay.
And, one only in the other. Right.
All right, Mr. Campbell. In cause number 21-36426, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle, and that's from November 28th of 2020. The indictment further alleges that you were previously convicted of assault family violence, a third-degree felony, December 5th of 2014. And how do you plead to that charge? So to the charge, let's start with just evading arrest or detention with the use of a vehicle from November 28th of 2020. How do you plead to that charge? Guilty or not guilty? It's guilty or not guilty. Either you did it or you didn't do it.
I thought that's what the plea was.
There's a plea agreement means in my court, you either enter a plea of guilty or not guilty. Mr. Campbell, I understand that you're already doing time for a murder and that you don't really care about what's going on today.
I'm saying I plead no content because he never even went over the indictment with me.
I find that hard to believe. So here's the
To
thing.
actually be honest, I just only been here for like about 30 days. So I got like 3 weeks or 30 days and about 2 weeks of being here.
Here's a picture of here.
Yeah.
So the nature of the crime, no cause number, and the magistrate, as far as the indictment, I never received one. And due to the fact of the nature of the charge of being from 2018, you have 5 years or 4 years to indict me to actually send that indictment. After
Sir, the allegation.
That's why I'm pleading no contest.
I'm not going to
I'm
allow.
fine guilty. It's fine.
Here's the thing. I don't have to accept any plea agreement.
Yes, ma'am.
Okay. So you can, in that evading arrest or detention case, if you go to trial and you're found guilty, it's habitual. You're looking at 25 to life. We can set it for trial. I'm not playing games and I'm not going to accept the disrespect. If you want me to follow this agreement and go along with the plea agreement and you can go on, do your time and be done with it, then we can get that done. But you're not going to show disrespect while we're doing it to me. Do you understand?
Yes.
So if you want to go forward, we'll go forward. If not, we'll set it for trial. Mr. Smith will get ready very quickly and we'll get your case tried within a month. And it'll be habitual 25 to life. What do you want to do?
It's 18 years.
No, the plea agreement.
If you go to trial, listen to me. If
Yeah,
you go to
fine.
trial and you're found guilty and your prior convictions, stop talking over me. If you go to trial and you're found guilty and those prior felony convictions are true, then you're looking at habitual 25 to life. Today, there's an agreement for something different. I'm glad to accept that if that's what you want to do, but you're going to either accept responsibility and plead guilty or plead not guilty.
Yeah.
That's your choices. So let's go back then and cause number 21-36426. You're charged with a 3rd-degree felony offense of evading arrest or detention with the use of a vehicle from November 28th of 2020. How do you plead to that charge? Guilty or not guilty?
That's what I'm saying. He's saying assault family violence. The invading arrest is I
Listen.
plead guilty.
It's evading arrest or detention
But
with
what
the
are you
use.
looking at? I'm saying
I'm looking at your indictment.
He's saying you got indicted for
I got that.
evading. In 2014, you were
Hold on,
convicted of
this,
something
Mr.
else. Okay.
You've probably already tried. Let me take care of it this way. Give me just a second. Which one is being dismissed? 5-1 or
39051.
okay.
Make sure you don't get my information mixed up with him.
Who's?
Or whoever that information is, I ain't gonna say his name on the record.
That's not me.
Yeah.
Just a second. Maybe it's taken care of. I should have 2 indictments. I just released. All right. Place that in front of your client, please. Now, that is cause number 21-36426. That indictment alleges in paragraph 1 that you committed the 3rd-degree felony offense of evading arrest or detention with the use of a vehicle from November 28th of 2020. How do you plead to that charge?
I just pleaded no contest. She didn't want to accept no contest.
How do you plead to that charge? Guilty or not guilty? We're not going backwards, okay? I already told you you're not gonna plead no contest.
Guilty or not, you plead guilty or not guilty. So if I'm telling you no contest, what is that?
It's nothing and it's nothing. You're not allowed, I can take a plea of no contest or I cannot take a plea of no contest. That is up to the court. You're not legally entitled to plead no contest if there's a plea bargain. I'm telling you, if you want me to accept the plea agreement, you're going to plead guilty or not guilty. I've already told you that. I'm not going to tell you again. If I have to tell you again, guilty or not guilty,
I'm saying.
period. That's your, I'm about to set your case for
That's
trial.
saying that I'm not, that's basically saying that
We're not going to argue the law.
I'm not, or I'm guilty.
We're not arguing
That's
the law.
basically just saying that I
Doesn't-
state that.
I'm not going to
Go
argue
ahead.
the law
Fine,
with
no
you.
guilty. Just sign, go ahead.
I
Put it
don't-
as guilty. Go ahead. That's what y'all want anyway. That's
Listen.
fine. I'm cool, ma'am. Just go ahead. and
Well,
get
you're
the
not,
guilty.
you're really not being cool and you're making me very frustrated.
Ma'am, I respect your call. Just go ahead and give me.
It, nothing here.
Plead guilty. There you
Okay,
go.
so you plead guilty to evading arrest or detention
Yes,
with
ma'am.
use of a vehicle. Okay. The next count, the next paragraph that you're looking at says that you were previously convicted of assault family violence, December 5th of 2014. Is that true or not true that you have that conviction
That's
on your
true.
record? Okay.
And that's not the same.
That's
case
okay.
As far as
Look-
evading arrest, ma'am, that's two different charges. So if you really want to be technical as far as being a habitual, that's called a repeated offender. But
Exactly. And that's, listen, so Mr. Campbell,
That's
that's,
15.
wow.
I think you.
Do you want to come sit up here and be the judge? You're so smart.
I don't know. If you needed some help, ma'am, I wouldn't mind.
I feel like I might because I'm not understanding. Mr. Campbell, you're getting a deal to go on count one only, which makes you a repeat. I get that you've been through this before and you understand what's going on, but you're making this more difficult. If you go to trial, you could be habitual. Today, if we take this great plea agreement, it's repeat. I understand that. I've been doing this for 30 years. Okay? So, did you enter your plea of guilty freely and voluntarily?
Guilty.
Did anybody force you to plead guilty today?
No.
Okay, so I have well, let's go to the next case then. In cause number, and here's that indictment. In cause number 22-39050, you're charged with and in this case, we're just going on count one.
Count one only.
So in this case, we're going on count one only. So it's just the offense of tampering with physical evidence, a second-degree felony from November 28th of 2020. And how do you plead to that charge? Guilty or not guilty?
Pleading no contest, but guilty now.
So are you pleading guilty to this charge?
Yeah. that's
Okay.
actually-
And did anybody force you to plead guilty in cause number 22-39050?
We just answered it.
I know I have to ask you in each case. It's required by law. It's required by law that I ask you that in every case.
Just pleaded guilty.
Okay. And nobody forced you to do that, right? Speak up so the record can take it
No,
down.
I think you did. You did, but let's go. So no.
Okay. So I have in both of those cases here on the tablet, some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed those, did you go over them with Mr. Parker? The documents on the tablet, y'all have that? And do you understand if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving any right to appeal? Yes or no, please? Do you understand that?
Understand what we signed, the document.
Okay, you have to answer out loud, yes or no, so that the record's clear that you understand, that I know you understand what you signed, okay? I'm not trying to, doesn't have to be that difficult. Just get in, get your deal and get out. You're making this way more difficult than it has to be. Do you also understand, if you're not a US citizen, that a plea of guilty or no contest could result in your deportation? If you're not a US citizen, could result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law.
So what this is, I don't.
I'm required to ask everyone that. Are you a US citizen?
Yeah.
Okay. State tenders number 1 in each case. It's admitted in each case. Is there any evidence that Mr. Campbell is not competent?
No, you're
You said
I just printed the wrong thing.
She asked me if I thought if there's damage you weren't. I said, no, there's not. He's confident.
I just printed the wrong stuff. Did I print both of the
Give him the
certifications?
thing on that shirt.
Okay. All right, Mr. Campbell, I'm going to find in each of your cases that you, Mr. Campbell, pay attention to me for a second, please.
Oh, fell, please. I ain't drinking,
Mr. Campbell, ready?
Yeah.
In cause number 21-36426, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of evading arrest or detention with the use of a vehicle. Find that prior conviction true. Sentence you in accordance with your agreement to a term of 18 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
So can you say that on record?
I'm on the record.
No, I'm saying say that how long I've been in custody.
I don't know. I don't have that information.
5 years.
Okay, you'll get all the credit that you are entitled to get by law. And cause number 22-39050, also find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of tampering with physical evidence. Sentence you in accordance with your agreement to a term of 18 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These two cases will run concurrently, which means together at the same time and concurrently with any other sentence that you're currently serving. I have signed a dismissal as part of this agreement in cause number 22-39051. I'm handing you in both of your cases the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read that written admonishment. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition or about how long it lasts, you can talk with your attorney. You can go back with the bailiff.
So do I get my papers for my time, sir?
Go back with the bailiff.
Is you gonna bring me my papers for my time, sir?
They have it in the jail.
Excuse me?
No, they have it at the jail. No. I told you.
You didn't tell me.
So I wasn't that bad.
I mean, this one might be difficult, and Judge, this one's really gonna push you over the edge. Difficult. This move. As you go over them with Mr. Parker. Brandon Clayton, Mr. Parker.
It was gonna be a big cold start day, probably, but I knew that it's not. I almost put his stuff in this file. He's getting on me for missing stuff.
I know.
Very much. Body. TV.
Good morning, ma'am. I probably should have sat down. I need a break. Shouldn't do it.
Excuse me.
Good morning. Are you Brandon Jamal Clayton? Good morning. And let's see, will your client waive the formal reading of the indictment and the motion?
Good, Your Honor.
Mr. Clayton, in cause number 26 DCCR 0229, you're charged with the third-degree felony offense of deadly conduct, discharging a firearm from January 5th of 2026. And how do you plead to that charge?
Good.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? In that case, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand that?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in that case.
No objection.
It's admitted. Is there any evidence that Mr. Clayton's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to find you guilty at this time, of deadly conduct, discharging a firearm. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 22-39186, I have a first amended motion to revoke your unadjudicated probation.
Judge, count 1 is, if we did 1 and 8, 1 is failing to report, 8 is the offense for which you just pled guilty.
Thank you. This motion shows that you were placed on probation June 8th of 2022 for the offense of aggravated robbery, and that was a 10-year deferred probation. Is that correct?
Yes, ma'am.
And the state's elected to proceed on counts 1 and 8. Count 1 alleges you violated your probation by failing to report as directed to the probation department July 2nd and July 17th of 2025. And is that true or not true?
True.
Count 8 alleges that you committed that new offense of deadly conduct on January 5th of 2026. And is that true or not true?
True.
Did you enter your pleas of true to counts 1 and 8 freely and voluntarily?
Yes, ma'am.
And because those counts are actually true?
Yes.
I also have some documents in this case that the state's marked as exhibit number 1 that have your signature on them. Before you signed these, did you go over them with Mr. Parker? And did you fully understand them as well? And you also understand, if I follow the agreement in this case, you'll also be waiving your right to appeal. State tenders number 1.
No objection.
It's admitted. In cause number 22-39186, I'm going to find that you entered your pleas of true to counts 1 and 8 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated robbery. Sentence you in accordance with your agreement to a term of 15 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you in each of these cases, they'll run concurrently, which means together at the same time, if I didn't already say that. I'm going to hand you in each of these cases the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. Also, I am going to find in cause number 22-39186 an affirmative finding of a deadly weapon. I'm also handing you the trial court a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. Good luck to you, sir. You can go back with the bailiff. Thank you, ma'am, for being here. Sula Hamden. And it shows as for bond hearing, but it looks like there's an agreement. Is that?
Judge, it is an agreement, Judge. It's a misdemeanor.
Take 60 days.
You got one of the Snickers, yeah.
I think I might have one more. I have been going through them. It's only March and. All right, are you Sulu Hampton?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the motion?
Hey, Your Honor.
Mr. Hamden, in cause number 24 DCCR 0759, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation October 7th of 2024 for a lesser offense of evading arrest or detention. I guess that really should say,
Yes, John, we should strike the with a motor vehicle.
any objection to
No
the
objection.
amendment? Did that. All right, so is the lesser offense of just evading arrest or detention a class A misdemeanor? That was a 2-year deferred probation and has been extended for a year. Is that correct?
Yes, ma'am.
This motion alleges that you violated your probation. Count 1 alleges that you provided a urine sample January 21st of 2026 that tested positive for methamphetamine, amphetamine, and tetrahydrocannabinol. And is that true or not true?
Yes, ma'am.
True or not true?
True.
And then count 2 alleges that you failed to pay your court assessed fees as directed. Is that true or not true?
True.
Did you enter your pleas of true to counts 1 and 2 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
Have some documents here on the tablet that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1,
No objection?
it's admitted. Is there any evidence that Mr. Hampton is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1 and 2 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty, and at this time find you guilty of the lesser offense of evading arrest or detention. Sentence you in accordance with your agreement to a term of 60 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows that this was an agreement that I followed, so you waived your right to appeal. All right, good luck to you, sir. You can go back to the bailiff.
Thank you, Your Honor.
Carl Ledet, or Ledet, Carl Ledet, I'm sorry.
My first case in this bench, she can't even make me a reasonable offer. I settled with Tommy.
It's super aggravated. That is a reasonable offer.
So this is a 25 to life one. Yes.
I may not have checked it right on the thing, but
Okay, I'll make that
He does.
modification.
I'm whatever.
All right, sir, is it Ledet or Ledet? And you are Carl Ledet? And Mr. Ledet, in cause number 25 DCCR 0579, you're charged with a special degree felony of an aggravated assault of a child, aggravated sexual assault of a child, from August 1st of 2024. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be a minimum of 25 years up to 99 years of life in prison without the possibility of parole. Do you understand?
Yes, ma'am.
And I have here on the tablet a document that you signed with Mr. Parker, this shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 30-year term in the institutional division of the Texas Department of Corrections, obviously with the opportunity for parole. You have every right to reject that offer and have your case set for trial. I want to make sure you understand what the possible consequences are if you go to trial, what your options are. Do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
Okay, we'll get that done. Ms. French, is there any reason to believe at this point that there would be any change in that offer?
No, Your Honor.
All right, so I do want to make sure you understand, Mr. Lede, that after today, there won't be, this offer will be off the table. You understand?
Yes, ma'am.
So what Mr. Lede, Mr. Parker represents you now. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am.
So, Mr. Parker, you're released. Mr. Ledette, we will appoint someone today. They should be out to see you very soon to begin preparation for trial.
Yes, ma'am. Thank you. Oh, nice.
All right, sir, you can go back to the bailiff. Travis Lewis, Mr. Parker.
Just off of the day if you come home. Well, no, not necessarily.
Today, I've come to the conclusion I do not have the temperament to be a judge. I've come to that.
Some days it takes a lot.
You wouldn't get my vote anyway.
Mr. Parker. I mean, we've been going, I'm still drinking coffee at the cold from this morning. I haven't even finished my cup of coffee yet today. All right, sir,
Good.
Travis Lewis. And will your client waive the formal reading of the indictment?
He will, Your Honor.
States that can proceed under 1244 of the Penal Code and punish this offense as a misdemeanor.
Thank you, sir. Mr. Lewis, in cause number 25 DCCR 0014, you're charged with the state jail felony offense of credit or debit card abuse, and that's from November 29th of 2024. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection?
It's admitted. Is there any evidence that Mr. Lewis is not competent?
No, Your Honor.
All right, Mr. Lewis, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of credit or debit card abuse. Sentence you in accordance with that agreement to a term of 60 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you've waived your right to appeal. And I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff.
Yes. You got it. You should have. Thank you. Thank you. Here. Just, I think the last one just need to go through the motion.
Mercedes Sias. I'm gonna have to take a break after this.
Got Pleasant on rushing out of dinner.
I know, and he was happy.
He's excited. You gotta.
Oh, okay, then I'll wait a minute.
I
can, wait a minute.
Oh, no,
Just gonna go through the motion, just. Hold on. Right here.
Good morning. Good morning. Are you Mercedes Science? Answer out loud, yes or no, please. And Mr. Parker, will your client waive the formal reading of the motion?
Sure, Your Honor.
Ms. Science, best you can, raise your right hand for me. Do you swear affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Yes, ma'am. Thank you, ma'am. You can put your hand down. Ms. Science, in clause number 18-29442, I have a motion to revoke your community supervision. Shows that you were placed on probation January 7th of 2019 for the state jail felony offense of driving with a child passenger. And that was a 2-year term in the state jail prison that was probated for 5 years and extended for 2 years. Is that correct? Yes, ma'am. This motion alleges you violated your probation. Count 1 alleges that you failed to work faithfully at suitable employment and provide verification of that. Is that true or not true?
Yes, ma'am.
True or not true?
Yes, ma'am. I had a lot.
Listen,
True?
yeah,
or not
true or not true?
True.
Thank you. And we'll go through the reasons and explanations at another date. Okay. Today, I just need to know if it's true or not true.
Okay.
Count 2 alleges that you failed to pay your court assessed fees as directed, and that as of December 11th of 2025, you were $6,707 behind in your fees. Is that true or not true?
True.
And count 3 alleges that you failed to make monthly fee payments in the minimum amount of $50 as directed by the court. And is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
Yes.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
All right, then I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, but I'm going to reset your case for sentencing and ask the probation department to do an updated report. That'll give me more information about what's been going on since we were here last, and then we'll come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Parker, and he'll present it to me on your behalf when we come back.
Yes,
All right, you can go back with the bailiff.
Okay.
Yes, not excused.
Thanks.
Right.
Miss-
Yes. Other science?
Can I? Imagine that. I didn't think I did. Yeah, somehow. Maybe I.
Have a good day.
You too, Ms. Lounge.
Ms. Perazzo, you have Thaddeus McCray.
McCray.
Maybe so. And this is an MTRP final reset. So are we just going through the motion?
This is the one that committed murder when he was on the EST. This is the guy we tried with Bruce, and the victim wouldn't show back up, so we had to plead him to the other ones. We have put him on probation, and that's when he got out. He built a new girlfriend, and we still waiting on that to be brought over.
So y'all still don't have the murder?
Hasn't been brought to us.
So I did discuss with Mr. Smith possibly setting or asking for a PR bond. He is on deferred probation.
No,
But
it's on
according
straight
to
deferred.
Hold on.
It's deferred.
It's deferred.
Right, yes.
So here's what I would ask, just so that everyone has an opportunity to prepare for any hearing.
Yes, ma'am.
If you'll get something filed today, we can set it next week.
Okay.
Mr. Smith, if you will get with the whatever agency has not turned that over yet, explain to them what's going on with this case and what's about to happen. I don't know if that will encourage them to get something over more quickly. I know there's probably information they're still gathering, but we'll get that filed today. We'll
Yes,
get it
ma'am.
set next week for a hearing on the bond on this case.
Yes, ma'am.
Okay, I don't think I'll have a choice but to give some type of relief at this point.
Yes.
Okay, thank
Okay.
you, Your Honor. Okay. See you next week.
All right, we'll reset it one week. Mr. Reynolds on Zurich trustee.
There.
rejection form. And the reason for that is they were backwards.
Okay.
The one said that aggravated assault was a first degree felony, and the other said the aggravated robbery was a second degree felony. So but the offer remained the same. Okay. They're in front.
Good morning. Are you Zarek Trustee?
Yes, ma'am.
Mr. Trustee, clause number 25 DCCR 0981. You're charged with the second degree felony offense of aggravated assault with a deadly weapon, and that's from June 19th of 2025. And what that means is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
And then in cause number 25 DCCR 0982, you're charged with the first degree felony offense of aggravated robbery. And that's from June 19th of 2025. And what that means is that if you go to trial and you're found guilty, the range of punishment is between 5 years and up to 99 years or life. Do you understand?
Yes.
In each of those cases, I have here on the tablet some documents that you've signed with Mr. Reynolds showing that the district attorney's office has made offers in your case if you wanted to enter pleas of guilty for 15-year terms in each case that would run concurrently, which means together at the same time. You have every right to reject that and have your cases set for trial. Let a jury decide if you're guilty and let that jury decide your punishment. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to enter a plea of guilty. Do you understand all of that?
Yes, ma'am.
And do you want to reject those offers and move forward with trial?
Yes, ma'am.
Well, if you don't know which way to go, the safest way is for you to talk to an attorney. Okay. Mr. Lawson, hand him an affidavit of indigency, please. All right, the court will find that you are indigent for the purposes of retaining counsel, and I'll appoint Attorney Aaron Aldridge to represent you in this matter. The court finds that there is probable cause that you have violated the terms of your ILC. I'm going to set this for a final hearing. You will remain in the Warren County Jail pending that final hearing. You can go with the deputy. Thank you, deputy.
Yes, sir. Thank you.
Is there any reason to believe that there's any other information out there that would change that plea offer?
Not at all, Judge.
So I do want to make sure you understand, Mr. Trustee, that after today, I will not accept this plea offer or agreement unless there is some new evidence.
Versus Chelsea Sumter. Ms. Sumter, the court has received a report that alleges that you have violated the terms of your ILC. Officer, could you read a statement of that allegation, please?
Yes, Your Honor. Ms. Sumter violated ILC condition number 7, and on December 4th of 2025, she submitted to a positive drug screen at treatment that was confirmed lab positive for methamphetamine. The defendant then later verbally admitted to the use of methamphetamine to her probation officer. On January 12th of 2026, the defendant submitted to a drug test that was positive for methamphetamine, and she admitted to use. And on February 24th of 2026, the defendant submitted to a positive drug screen for marijuana and admitted to use. And special condition number 15C, to date, the defendant has failed to comply with mental health treatment as ordered at her ILC violation hearing on 8/18 of 2025.
All right, Ms. Sumter, do you understand those allegations?
Yes, sir.
You have a right to be represented by counsel. If you cannot afford an attorney, I will appoint one for you at no cost. Do you have the funds to hire an attorney?
No, sir. I'm not going to hire an attorney.
I didn't know. I didn't ask if you were going to hire one.
I'm sorry.
Do you have the funds to hire one?
No, sir.
Do you want me to appoint you one?
No, sir.
You want to waive your right to counsel?
Yes.
All right, Mr. Lawson is going to hand you a form that is a waiver of counsel. You need to read that very carefully because you're giving up a very valuable right that you have. All All right, Ms. Sumter, did you sign this document?
Yes, sir.
Do you believe you understand what it says?
Yes, Your Honor.
Has anyone promised you anything or threatened you in any way to get you to waive your right to counsel?
No.
Are you under the influence today of any drugs or alcohol?
No, sir.
Do you take medication that interferes with your ability to understand what's going on?
No, sir.
All right, I'm going to make a finding then that you've made a knowing, intelligent, and voluntary waiver of your right to counsel. I will accept that. I'm not going to dispose of this today. I'm going to set this out for 30 days for a final hearing. You are required to be back in here. Before I sanction you for this violation, I want to see what progress that you have made in accordance with the instructions of your probation officer, Officer Vreta. Do you understand?
Yes, sir.
So more positive tests. You seem to be blaming your employment or whatever. Are you engaged right now? Engaged in treatment?
I am.
All right. All right, no more positive tests. I'll see you in 30 days.
All right, thank you, sir.
Well, if you want to go back down, I'll meet with you when I get done here. Yeah.
This is case number 22CR39541, the state of Ohio versus Dakota Roberts. Mr. Roberts, the court has received a report that alleges that you have violated the terms of your supervision. Officer, could I have a statement of the allegation, please?
Yes, Your Honor. The defendant has violated general condition number 7 in that on October 27th of 2025, January 13th of 2026, and February 24th of 2026, the defendant submitted to drug screens with positive results for marijuana and admitted to using the substance.
Mr. Roberts, do you understand the allegation?
Yes, sir.
You have a right to be represented by counsel. If you cannot afford an attorney, I will appoint one for you at no cost. Do you have the funds to hire an attorney?
No, sir.
Do you want me to appoint you one?
Yes, sir.
All right, Mr. Roberts, the court will find that you are indigent for the purposes of retaining counsel. I'm going to appoint Attorney Aaron Aldridge to represent you in this matter. The court finds that there is probable cause you have violated the terms of your supervision, and I'm going to set this for a final hearing. Now, tell me why I should not take you into custody right now.
I'm the only one working at my home. My 3 children and my wife, I'm the only one that has a job right now. I'm taking care of all of them, and I'm trying to get my life back together, Judge. I'd like to go back to the Talbert House for counseling if I could. I was doing really good when I did that. I just had somebody really close pass away to me not too long ago, and it's just kind of been taking a toll on me. And I was wondering if I could get back over there to talk to somebody about it, maybe.
Well, again, people grieve loss of loved ones all the time and do not resort to drug activity.
Yeah, for sure.
If you really, really want to support your family and work and stay out of custody, stop smoking marijuana. This is not the first time you and I have had this conversation, according to my notes.
Yeah, we had
Back
this
on
conversation when
November 2nd of 2022. So over 3.5 years ago, I admonished you on the record, and I can pull up the video if you'd like.
I just said, you said it when I first got put on. You did.
This is your last warning. All right, I'm going to set this, I'm going to appoint attorney, set this for a final hearing. I'll let you stay out of custody right now. Did we get a test on him today?
Yeah, Torek got it.
Was it sent out to the lab?
I will ask Officer Torek. If not, would you like him to resubmit to a test and have it sent out?
Yes.
Okay.
I'm gonna determine what your THC level is, Mr. Roberts, and I'm gonna tell you right now, if it goes up, you're going into custody. So when you come back for your final hearing, if those results aren't changing drastically, you're going to be waiting this out in the county jail. then I'll make sure that you're negative. Are we clear on this?
Yes, sir.
I don't know how to get through to you. The use of marijuana, number one, I ordered you not to use it, but it's not helpful to you. You're hurting yourself. You have a substance use disorder. You need to stop using it, period.
Yes, sir.
So you make the choice. If you want to serve this time out in jail, that's fine. Because I will not listen to, I have to support my family. Then support your family. Stop using drugs, period.
Yes, sir.
I'm sure your kids would much rather have you sober than stoned. All right, you'll be notified of the final hearing.
Yes, sir.
I'll double check. Mr. Roberts, you can go back down to.
That comes to light that Mr. Reynolds or your attorney, or the state's attorney doesn't know at this point. And so we'll get it placed on that trial docket and Mr. Reynolds will begin preparation for trial. All right, you can go back with the bailiff.
Judge.
Thank you. And then Mr. Lewis did something. Eric Segrist. Okay. Eric Segrist. Thank you, Mr. Lewis, for working in. Which 36. And then there'll be a dismissal of another. Correct. They're not.
Yeah, that's all I did. Yeah.
Okay.
But she knows something I don't.
So that.
I just saw some of these. I'm business on the business. I'm available. Wait till you see what I have on you right
All right, sir, again, you're Eric Segrist Jr.
Yes, ma'am.
And Mr. Lewis, will your client waive the formal reading of the indictment?
He does, Judge.
Mr. Segrist, in cause number 25 DCCR 1836, you're charged with the second degree felony offense of burglary of a habitation from October 24th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you did what they charged you with?
Yes, Your Honor.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, Your Honor.
The documents that you signed today, did y'all go over those?
Yes, yes. Your
And
Honor.
do you fully understand them?
Yes, Your Honor.
And do you understand if I follow the agreement that you've made with the district attorney, that you'll be giving up any right to appeal? So if I follow the agreement, you can't change your mind later. Do you understand?
Absolutely.
And it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated. You'd be on probation for 5 years. You would be ordered to pay a $500 fine and to follow all of the rules and conditions of probation. Do you understand?
Yes, ma'am.
Hold on. Do you also understand that if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, Your Honor.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Segrist is not competent?
No, Judge.
All right, sir, did you have a question?
Yes, ma'am, about my mental health. I was wondering, would I be sent to like spinal tap so I can get the right kind of medications?
So here's what's going to happen. Absolutely. If there's any kind of issues, that's exactly what probation is for, is to help you get past any issues. What I'm going to do is reset your case for sentencing. And the probation department will do a pre-sentence report. And I'll ask them to do any kind of evaluations if they can between now and then.
Yes, ma'am.
Any help that you need, I'll order it as a condition of your probation. And so we'll take care of all of that when we come back for sentencing.
Because I'm schizophrenic and I wanted to get help with like mental health use.
All right, we'll get all, yes, we absolutely, I appreciate that you're letting me know that. Probation is over there now. She's making a notation of it so that they'll discuss that with you when they come out to do that pre-sentence report, and we'll have a plan in place when we come back for sentencing.
Yes, ma'am.
Okay, you can go back with the bailiff.
Thank you, Judge.
Okay.
I don't know if I said everything I was supposed to. I'll say it for sure. When we come back, I'll be say it. Good morning, Mr. Udishin.
Good morning.
Oh, I can't hear you. Uh-oh.
Let's see.
Hold on. Let me see if that's us or not.
And I can't see anybody. Let's see. But I can hear you. There, I see everybody now.
Say something. Can you,
Yes, can you hear me now?
hold on a second. Let me get my
All right.
clerk in here to help us. For some reason, I can't hear Mr. Udishin. I don't know where the volume is. If he, thanks. Thank you. It should be. There's no sound coming from Mr. Udishin. Does he have his own? Yeah, he's not muted.
Not muted.
Yeah, he's not muted. So I don't know where.
But does he have that? That would, I think, show if you muted your.
No, it would show here if he's muted. Yeah, he's not muted. See, I can mute him if I want to myself, so that wouldn't be there. Hold on. Is it the TV or the Elmo?
The Elmo's on, or else it wouldn't be on the TV.
Uh-huh. And I know the TV was turned up yesterday. We have the sound. We might do this, Mr. Udishin. I might end the meeting, start all over, and see if we can get you to rejoin, okay?
Okay.
I don't know what else.